I appear on behalf of WPSC.
But I appear for the petitioner, my lord.
Respondent number 5.
But this is my affidavit of service. But the petitioner, no, my lord, the petitioner lodged a complaint with the distribution licensee that the private respondent has been running a submersible pump, my lord, without following the 200-meter norms, my lord, without maintaining the 200 meters distance norms from the existing submersible pump of the petitioner, my lord. But page 22 is my complaint, my lord, before the authority. And but I have got the my electricity connection for running my the submersible pump, page 21, my lord. And the page 22 is the complaint which is pending before the authority, my lord.
Page 17 is the last page.
Page 7.
Page 17 is the last page.
Page 15, my lord.
17073.
17727, my lord.
কি দিচ্ছেন
17727.
ফাইল দিচ্ছেন
দাদা
Yes, page 21.
Page 22, my lord,
22.
is my complaint. And my lord, the petitioner has been, my lord, the electricity connection.
But I was told, I have not been shown the law that this 200-meter rule has been done away with.
Yes. Yes, Lord.
and my lord, it doesn't fall under the semi-critical or critical area.
Lordship, Sagordigi is a green zone. And green zone law does
green
not
zone.
prohibit.
If the law does not prohibit, then they are entitled to take electricity supply. It is only if you can show a prohibition.
my
that
lord,
they will be
but
prohibited.
there are, my lord, the decision of the honorable coordinate bench, my
No,
lord.
but that might have been rendered at a time when the regulations were in place. Now the regulations have
Sagordigi is
been
a
taken
green
away.
zone.
Green zone. Safe zone.
The regulations are no longer in force.
Right.
If they have lost force, then
Right.
in that case, how can you rely on the prohibition?
And in 2024, my lord, the
green zone.
Sagordigi falls under green
These
zone.
have to be shown. One is that it falls within the critical or semi-critical zones where the prohibition applies, and if the prohibition at all applies even today.
My categorical instruction is it is in the green zone and it doesn't fall under the critical or semi-critical. That is the reason the total distance is 130.
Why don't you inform him by saying that in the
Right.
in response to a representation?
Right.
That is not. And my lord, there is one
That
more
will
thing.
that will help him also and you also.
And Lordship, respondent number.
There was a judgment of Justice Ishishila and then Justice Olive. That was
Yes, Mr. Kole only told me. Now I recall. He only told me in another matter, but it has been adjourned for taking. Even otherwise, there is nothing.
because after 2005 Act, the one
এখন আর নেই তো করে।
No, but then if there is indiscriminate boring, then in that case the groundwater will be depleted.
did by district magistrate, there is a committee.
They have to
They are
decide.
the district magistrate.
No, but is it the case that in all cases when you receive an application for grant of electricity supply to a submersible pump, you refer it to the committee for a decision?
We see the certificate.
Certificate by
Straight certificate,
By
madam.
the State Water Investigation Department.
the application as a prerequisite has to contain with it the
Yes,
certificate
yes,
also.
Street certificate has to be.
In this case, it was there.
No, it is in the green zone, my lord.
Sagordigi, it is
There
not
it is
needed.
not required
Not
at all.
needed. Sagordigi itself, my lord, has
Yes,
been
same
declared as.
Inform him about that. That will help
Will
both of
inform.
you.
And
Brother, there is an amount pending of 98,000 in her account.
That you take. You cannot be worse off.
Respondent number 5 has complied with all the formalities for the Ghana. They have objected
Record your
physically.
submissions. He cannot be worse off in his writ petition. In his rectification, he will walk away with an order.
The last two lines says the 98,268 is required.
পুলিশ কেস
And there is a theft case.
You just consider and say whatever you have to say.
As your lordship, please.
This
এইটা কি করে দেবো?
writ
সেটা
petition
আমার
alleges
instruction এর কথা।
arbitrary action on the part of the
Yeah,
WBSC
126.
authority.
I am for the respondents. Last occasion also, my lord, they didn't turn up.
লিখে নিন none appears for the petitioner. No accommodation is prayed for. Take same order.
Same.
Next.
Seven, my lord. I am for the respondent. Same.
Call করে দিন
Yes. Yes.
Huh.
Earlier occasion also, my lord, they didn't turn up.
7 same order.
Grateful.
But I appear on behalf of CSC in this matter.
Same order.
It is আটটা এটা for WBACTC, I'm sorry.
You write it properly and give.
Amen. ঠিক আছে ঠিক আছে
My lord, Mr. Konakuran Bandapatay. This
My lord, on behalf of I am for the petitioner, I am praying for kindly pass over the matter. My learned senior is busy in another court.
Can fix another day.
It is appearing under the heading for dismissal.
Not pass over.
Yes.
Another court busy.
In that case, we can ask for a next.
Very well. Not today.
Much obliged, my lord.
Ask him to be there tomorrow. I'll dismiss it otherwise. Next.
But I appear on behalf of CSC, my lord.
May I, Lordship? In this matter, I am for the petitioner, Lordship. Here is the affidavit in reply, Lordship. Lordship, in their report, Lordship, they have complied the court order and they are intended to give the electricity line.
My opposition, my lord.
What is this matter about?
But earlier, my lord, there was a dispute in respect of whether the building is authorized or unauthorized. But
Yes,
subsequently,
now it is
there
authorized.
Yes,
was direction for filing reports. We have filed the reports. My lord will straight away come to my affidavit in opposition, my lord. Page 6, paragraph, my lord.
H.
4G. My opposition, my lord, page 6, paragraph G, 4G. It is stated that the portion identified by the petitioner during inspection held on 3/5/25 is technically feasible to draw a service cable for catering supply to the premises subject to necessary compliances, and police help is required during installation of service owing to persistent objection at the locale. It is stated herein that the CSC is ready and willing to give service connection to the premises of the petitioner with police help through the portion identified by the petitioner during inspection. Since the said portion identified by the petitioner is safe and technically feasible, the said service connection can be provided. In respect of illegality of the building, my lord, it is the municipality who is going to do. We are ready and willing.
Lordship, municipality also given me the no objection, Lordship. And
Municipality is added as a party here.
Yes, municipality.
The municipality never appeared, it appears.
No, I think the
Municipality is
No,
not a party.
no, Lordship.
At the municipality a party. What is the name of the municipality?
Manad, it is,
Lordship.
Manad, get it from the just page number 5, Manad will come to paragraph E,
Lordship.
Uttarpara Kurton municipality.
May I, Lordship, hand it over this?
লেখা আছে আমার
Since
Hey,
the Uttarpara Kotrang municipality and its chairman or somebody should be made a party.
Yes, Your Lordship, I have the copy, Lordship. They have.
They have given a no objection. I have also annexed.
And its relevant official করে দিন Uttarpara Kotrang municipality and its relevant official. Leave is granted to you. I have written that you after the order is served, you come and do it tomorrow. You can do it. I'm good. Yes.
I'm grateful.
এক মিনিট
তো তোমারও হয়ে গেল তো তিনটে হয়ে গেল
এক মিনিট মালটা in this matter I am for the WBSc TCL. Well, this subsequent development is, my lord, the IPCL has gone into liquidation. Now NCLT matter is pending. RP was appointed. We have claimed our lodge to the RP.
They have not
And
cleared its-
moreover, my lord, the subject matter relate to this order pending before the Supreme
None
Court.
appears for the petitioner. No accommodation is prayed for. ওই আগের অর্ডারটা 17th এও appear করেনি
এটা মনে হয়
dismiss for default.
11.
Well, I'm appearing for the,
You are appearing.
no, I think that's, no, well, kindly take up the for consider. I mentioned it yesterday.
Oh.
Well, on 17th July 2026, this order was passed.
Yes.
Well, now the point is, your lordships, petitioner now IRP has been appointed, and that was on 15th May. So this was not brought to your lordships notice. So your lordships kindly steps are being taken.
So the RP should represent.
Exactly, man. Now we will be representing. So
লিখে নিন।
ওইটাই আমি বলছিলাম
অর্ডারটা কই অর্ডারটা একটা দিতে হবে
ওইটাই আমি বললাম জজ সাহেবকে আজকে আমারও তো জানা
I'm appearing for this petition.
But I appear for respondent number 2.
Your Lordship, I'm appealing for DV signing led by Rajeshwar Dutt.
But one of the issue is whether the control period for determining the tariff area can be curtailed to 3 years. But this issue is pending before the division bench and also the single bench. But let this be adjourned for some time and let us see what happens.
Yes, my lord, that can be done because the issue is pending before the division.
Kindly adjourn it cyanide, my lord. Thereafter, we'll mention this.
And they have not filed their reply, my lord, 1 year.
In the meantime, we'll file the reply, my lord.
I have filed my affidavit in opposition.
Well, we'll
have
file
also
our
filed our
reply. Kindly
opposition, Your
extend the time
Lordship.
period. We'll file our reply.
Very well, my lord.
Both Mr. Chakraborty as well as Mr. Dotto submit that the issue involved in the present writ petition is pending consideration before the Honorable Division Bench. Full stop. Comma in another matter. Full stop. Paragraph. Mr. Chakraborty prays for extension of time to file affidavit in reply to the affidavit in opposition filed on behalf of the West Bengal Electricity Regulatory Commission
And as well as DVC, my lord.
as well as the Damodar Valley Corporation. Full stop. Let such affidavit in opposition be filed within 4 weeks from date as prayed for. Full stop. Paragraph. List this matter in the combined monthly list of September 2023.
Well, after vacation, my lord. That's after vacation, my lord.
Let it appear in
Sir,
September,
my-
then we,
my lord,
by that
yes.
time, if the Division bench
There is one coordinate bench which says control period can be less than 5 years.
And that's
that is
why.
under- that
Well,
is under-
that issue is, well, what happens, well, I tell you, well, the tariff policy of
In any
2000.
case, the pleadings are also not complete.
So,
Very
well, tariff policy of 2006 and 16 says it has to be 5 years. Now, the whether they can go against the tariff policy or not, in terms of section 61, the language is guidelines. Shall
Mr.
and
Chakraborty,
guidelines.
we will come
These are
back.
the things.
Let's not disturb the court.
But
with
I
this.
have not disputed that the coordinate bench has gone against me. That's why we have
Wait a
gone to
minute,
division
stand
bench.
before the division bench. Let us wait for
But
some more time.
even a single year tariff can also be treated as the multi-year tariff. That has
Well, with deepest
right,
respect, I do not want to go into these issues, but possibly that is not the correct proposition.
We'll go into it.
A single and multi-year tariff are, if they are to be treated on the same path, I do not know the difference of meaning. Well,
place.
Grateful.
Thank you.
But I appear for WPCTCL on the last occasion also, my lord.
Oh, same order, dismiss for default. Next.
My lord, 14, my lord, I am for the petitioner.
Lordship.
It is the matrimonial suit. I pray for expedite hearing. My lord, suit is started in the year 2022. And my lord, next date is fixed on 17/11/2026 for my lord, preemptory hearing, my lord, PH. My lord, 4 days have been passed for preemptory hearing, my lord, that it was not taken, though I was very much present on each and every date. I am for the plaintiff, my lord. Yes, my lord, husband, plaintiff husband, my lord. My lord, already 4 years have been passed, my lord.
All right, all right. This revisional application seeks expeditious disposal of matrimonial suit number 538 of 2022, pending before the learned fast track court -3 at Barrackpur, district North 24 Parganas. Full stop. Usual paragraph. Therefore, having heard the learned advocate appearing for the petitioner and having considered the materials of the cause, this revisional application is disposed of by requesting the evidence has not yet begun.
No, not started, my lord, not started.
Requesting the learned district judge, fast track court 3, Barrackpur, North 24 Parganas, to dispose of matrimonial suit number 538 of 2022 as expeditiously as possible and preferably within a period of 1 year from the next
My lord, kindly 8 months, my lord, kindly 8 months, my lord. My lord, kindly 8 months. 4 years have been passed.
Then it will be only as expeditiously as possible.
No, my lord, 1 year, 1 year, my lord.
As expeditiously as possible without granting any unnecessary adjournment to either of the parties.
My lord, preferably, my lord, 1 year, my lord, 1 year, my lord. Kindly see, my lord. I am for the litigant, my lord. My lord, for 1 year, my lord.
Necessarily, yes, 1 year.
Highly obliged, my lord. Highly obliged.
My lord, I am again before your lordship with that matter regarding, my lord, the threshold limit.
The bench will be there day after tomorrow. Unnecessarily, you are mentioning this.
My lord, they are about to take possession, my lord.
For so long they haven't taken possession. Now
My lord, they have
No,
issued, my lord, a fresh notice, my lord, of taking possession, my lord. They are issued.
Ganguly, day after tomorrow the bench will be there. Why are you disturbing them? Let them
My
have
lord,
their...
in that,
Ask my client not to take.
They have
my
not...
lord, kindly record an order to so that,
I'm saying it will go before the regular bench. This is not that.
my lord, kindly record an order to that effect, my lord, kindly.
of relief, since there is a flux of determination between.
Kindly allow me to come back tomorrow. Today nothing will happen, my lord. Today nothing will happen. Because today is 30th, my lord. They have time till today.
And what was your point?
My lord, my point, my lord, your lordship has considered, my lord, the threshold limit, my lord, which has been fixed, my lord, by the notification is 20 lakhs. And my lord, my financial accommodation was, my lord, for 4 lakhs only. And my lord,
Mr. Ganguly, why are you after him for 4 lakhs?
But I am not after him for 4 lakhs. I am before your lordship to settle this point of law. I want to satisfy on the point of law. I am not asking.
Settle it without going after him.
But my lord will appreciate.
If it was a big, some big businessman,
This is a
somebody gets an housing
misunderstanding.
loan 4 lakh, he will get it.
My lord, this is a misunderstanding of the order passed by the honorable coordinate bench, my lord. In every way, my lord knows better than me. They are showing this order. See, the housing finance company cannot invoke their SARFAESI action even if the loan is claim is amounting to rupees 19 lakhs 99,000. That is the problem.
no, my lord, the division bench, my lord, has also clarified, my lord.
Point, tell me.
My lord, kindly, if your lordship, my lord, kindly takes the division bench's judgment, my lord, I'll, my lord, clarify. This will, my lord, clarify the position.
It will take time because these.
It will take only 5 minutes time. So far, I understand what I have done, matters to your lordship. It will take only 5 minutes. I'll show from the statute itself. I'll not go beyond the statute.
Yes, Mr. Mukhopadhyay, tell me.
My lord, as your lordship, my lord, is aware, my lord, my loan is, my lord, 4 lakhs. And my lord, they have admitted themselves to be NBFCs, my lord. In their application under section 14, my lord, they have admitted themselves to be an NBFC. And if your lordship, my lord, takes the division bench's judgment of this court, my lord, presided over by Justice Shampa Sarkar, my lord, paragraph, my lord, 24 onwards.
24
onwards.
Yes. 24.
23, my lord, his lordship, my lord, rightly held, based on the classification of an HFC in the master circular, the direction and press release of the RBI, read with the definition of NBFC under section 14 IF of the RBI, the applicant number 1 was an NBFC. Section 45 IF defines an NBFC company as a financial institution, which is a company. My lord, the 45I has been quoted here. My lord, a financial institution, which is a company, a non-banking institution, which is a company, and which has as its principal business the receiving of deposits under any scheme or arrangement or in any other manner, lending in any other manner. Such other non-banking institution or class of institution, my lord, my learned friend claims to be the financial institution under subsection subclause 3, my lord, is a such other non-banking institution, class of such institution as the bank may, with the previous approval of the central government. My lord, this notification, my lord, has been quoted in the next paragraph, whereby, my lord, the HFC
paragraph means paragraph 25.
Paragraph 24. HFCs, my lord, has been considered as financial institutions, my lord.
Very well. Then,
my lord, your lordship kindly see paragraph 25.
25. Yes.
Yes. Under the RBI Act, NBFC has already been discussed herein above, includes a financial institution which is a company. The notification of June 17, 2021, read with definition of NBFC, non-banking financial company under section 45 IF of the RBI Act, establishes the fact that central government had specified HFCs registered under subsection 5 or section 29A of the National Housing Bank Act 1987, having assets worth 100 crores and above, would be a financial institution for the purpose of SARFAESI Act. Now, my lord, the financial institution definition has been quoted. And my lord, how your lordship is dealing with the HFC, my lord, is paragraph 26. A combined reading of section 221M4 of the SARFAESI Act and the notification of June 27, 21 and section 45I(f) of the RBI Act clearly indicates that the HFCs were brought under the fold of NBFCs. His Lordship rightly appreciated that the amendment on August 29, 2023, which was relied upon by Ms. Ojha, has been repealed and replaced by Master Direction of October 19, 2023. Being the Master Direction, RBI Financial Companies Scale-Based Regulation Direction 2023, Regulation 2 thereof, provided that the regulatory structure of NBFC would be in 4 layers based on size. My learned friend belongs to medium layer, and above asset of 100 crores. And regulation 2.3 clearly specified that the middle layer, including housing finance companies as NBFCs. This is what the division bench's specific finding, the middle layer HFCs having asset worth more than 100 crores are NBFCs. Regulation 4, which relates
There is no
of the direction.
there is no contest to this that they are in NBFCs. They also say that they are NBFCs.
Now,
So
what
you
they
don't
try
labor
to
on that. What is your next point?
What they try to indicate with your Lordship is that if your Lordship kindly takes the notification once at page 18 of my application.
Yes.
Sixth line from bottom. As regards things done or omitted to be done before such supersession, the central government hereby specifies such non-banking financial companies as defined in clause F of section 45I of the Reserve Bank of India, having asset worth ₹100 crore and above, which shall be entitled for enforcement of security interest in the secured debt of ₹20 lakhs and above. My lord, what they try to say, my lord, they are not notified under section 45I. My lord, but this notification does not restrict its application to the only notified HFCs, my lord. It does not say only the notified HFC or NBFCs will be governed by this notification. My lord, this is meant for the NBFCs, and they have claimed themselves to the NBFCs to be able to a financial institution to invoke the provisions of Surface Act. Now, my lord, they cannot take go away from this notification, my lord. This is my humble submission before Lordship.
If you are defined under clause F of section 45I of the RBI Act, you are not defined.
I am not.
Then how do you claim to be an NBFC if you are not defined?
NBFC, so far regulatory purpose is concerned. What my learned friend is relying upon, there the appellant was a company.
If you are an NBFC, you are an NBFC. You can't be an NBFC for one purpose and not for another.
My lord, there are certain classification. I'll show. My lord, kindly comes to statute section 2M4 of Surface Act. I'll go it alone. ওই পেজটা খুলে দাও।
Yes.
My lord, kindly comes 2M
2M4.
That defines financial institution means our I come under 4. Now, my lord, may I be allowed to read it out once? Then I can only satisfy your lordship. Any other institution or non-banking financial company as defined in clause F of section 45I of the Reserve Bank of India so and so, which the central government may by notification specify as financial institution for the purpose of this act. Now I'm getting 3 things here. 1, any other institution. 2, non-banking financial company. 3, time to time central government may specify the classification of the company. So 3 things I'm getting from the statute. Now what kindly comes to the notification which my learned friend has referred. Page
80, page number 18.
80.
18.
1. Now, my kindly comes page 18. My who has issued this? Ministry of Finance, Department of Financial Service under Central Government of India. Now, my lord, may I be allowed to read this notification carefully? In exercise of the powers conferred by subclause 4 of clause M of subsection 1 of section 2 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, and in suppression of notification of Government of India Ministry of Finance number so and so dated 27th August 2018 and so and so, except as respect things done or omitted to be done before such suppression, the central government hereby specifies such non-banking financial companies as defined in clause F of section 45F of the Reserve Bank of India Act having asset worth rupees 100 crore and above. So, my lord, this notification relates to NBFC of 2M4 because this is for the companies NBFC is registered under 45I of Reserve Bank of India Act. Now, my lord, now any other is left. Here, my lord, this confines to the company, non-banking financial companies.
You are not
I come
company under 45F.
Yes, I do not come under that. I do not come under that. That is why I am in any other. Now, kindly see 17 to 2021. নোটিফিকেশন দিচ্ছি সব তো আরেকটা কোথায় গেল একটা লাগবে তো But I believe I have given 2 copies to your lordship. আমি এটা পড়ে দিচ্ছি আমার কাছে হয়তো আছে আমি পড়ে দিচ্ছি
45I.
But kindly comes now who has issued this?
No, let us first see 45IF.
Yes, last one was 45IF for the NBFC. Now, my lord, kindly sees the notification dated 17 June 2021 published after that notification. In exercise of the powers conferred by subclause 4 of M of subsection 1 of 2 of the SARFAESI Act and in suppression of so and so, except as respects things done or omitted to be done before such suppression, the central government hereby specifies such housing financial companies registered under subsection 5 of 29A of the National Housing Bank Act 1987 having assets worth rupees 100 crore and above. So, my lord, I am not a NBFC so far 45I is concerned. I am a financial institution in terms of section 5 of NHB Act. And my lord, this notification was issued by Central Government of India subsequent to the notification passed for the purpose of NBFC. Now, my lord, kindly see August 13 ব্রিফের মধ্যে থাকবে ব্রিফের অগাস্ট 13 ওই পৃষ্ঠাতে থাকবে আমাদের ভাঁজ করা বিষয় অগাস্ট 13 এটা একটু দিন না দিদি এটা একটু দিন this was the press release issued by Reserve Bank of India দিচ্ছে আমার এখানে August 13, 2019. And my lord, kindly recollect that my notification of 17 June 2021 subsequent to that. The Finance Act so and so has amended the National Housing Bank Act 1987 conferring certain powers of regulation of housing finance companies with Reserve Bank of India. The central government has since issued notification appointing August 19, 2019 as the date on which the relevant part of the Act, namely Part 7, Chapter 6, shall come into effect. HFCs will henceforth be treated as one of the categories of non-banking financial companies for regulatory purposes, not for the purpose of the SARFAESI action. Reserve Bank will carry out a review of the extant regulatory framework applicable to the HFCs and come out with revised regulation in due course. In the meantime, HFC shall continue to comply with the direction and instruction issued by the National Housing Bank till the Reserve Bank issues a revised framework for the purpose of regulatory purpose. Business, my lord. NHB
How do
will.
you differentiate the two, that the regulatory purpose?
I will show that.
Show that immediately, because that I have understood.
আমাকে আমার ওই প্রোফাইলটা তো যেটা পাতলাটা ছিল। Well, this is the master direction updated on April 15, 26. আমি কপি পড়ে কপি দিয়ে দিচ্ছি। হ্যাঁ আমি সেটাও দিয়ে দেবো। Kindly turns the page.
Yes.
In exercise of the power conferred under 45L and 45MA, the Reserve Bank of India Act 1934 and Section 30, 38, 32 and 33 of the National Housing Bank Act and all powers enabling this in this behalf the Reserve Bank having considered it necessary to the public interest and being satisfied that for the purpose of enabling the Reserve Bank to regulate the financial system to the advantage of the country to do so and to prevent the affairs of housing finance company from being conducted in a manner detrimental to the interest of investors and depositors or in any manner prejudicial to the interest of such HFC. Hereby issues to every HFC the Reserve Bank of India Direction 2025 hereinafter specified. Now, I kindly sees the applicability. This direction, except direction contained in Chapter 9, shall be applicable to housing finance company referred to as HFCs and individually as an agent registered under Section 29A of the NHB Act. So, I am not a company under 45. So far, regulatory business is concerned, they are RBI to supervise. That is also mentioned. Now, my lord, kindly sees the applicability of the directions. All directions are in the nature of regulatory. Now, my learned friend has referred the judgment passed by the Honorable Division Bench, wherein the appellant was a company under 45I. Although name is Piramal Capital Housing Finance Limited, because my lord, Piramal Capital earlier it was a housing finance company. Thereafter, it converted into a company under 45I, financial institution under 45I. That is the discrimination, my lord. And my lord, I am carrying that conversion certificate of ROC, my lord. And my lord, may I be allowed to refer only one judgment? Virender judgment.
You will take 5 minutes, but I will have to devote a lot of time. So you better go before the regular bench. I will not be able to conclude today now.
Well, that is why, my lord, otherwise I would not have bothered your lordship.
Yes. So why don't you take instructions and come? Because if it was a regular determination, I would have kept it, decided it. This way it can't be, because this decision.
In that case, my lord, may I come back tomorrow? May I take instruction from my client that they will stay their hands from taking possession of his property? And my problem, how long I'll take that instruction, that is the problem.
No, it will be for a limited period, and I will record that it will not be unless he moves it and gets a stay subsequently.
Yes, my lord, that
I will record.
Man, may I come back tomorrow?
Because it can't be done in a slipshod manner. It's interesting, but only if I have determination.
Now, my lord, have this determination.
This is not that matter, because not today করে রাখো।
এই তাহলে এগুলো আমি নিয়ে যাচ্ছি
লিখে দিন একবার as requested by Uh-huh.
I'm grateful.
Lordship, I beg to appear on behalf of the petition, led by Mr. Arijit Bardhan. He's in Supreme
Where is
Court.
he?
He said he will appear online, but his matter has been taken up in Supreme Court.
What is this matter?
Lordship, the petitioner, Lordship, may I just give my lord a brief first? Lordship, the petitioner is challenging formation of an internal committee under the prevention of sexual harassment.
Why can't you move it day after tomorrow? What is the problem?
Day after tomorrow?
Yes, the regular bench will be available. It's not
Lord-
that.
Yes, because Lordship, the
Happen in 2 days, what will happen?
Lordship, the difficulty is that the petitioner has subsequently been served with a notice that his services will be terminated because POSH Act, Lordship, has culminated into the inquiry. Inquiry has culminated into and কি বলে? He has been issued. No, a notice has been issued, Lordship, whereby his service may be terminated by next week. That is why, Lordship,
Next week. So it's
next week starts on Monday.
day after tomorrow, day after.
Lordship,
the bench
Lordship,
will be available. Why
Lordship,
not?
Lordship kindly hears
You
me.
have your
Lord,
bench tomorrow, day after tomorrow. Court is
Lordship
open.
kindly hears me out. Lordship, I will just take 5 minutes to try
He
to.
says that, but ultimately it boils down to I will not be able to take up my determination.
Lord, it is a pleasure always to move before my Lord.
That is just pumping.
Lordship, this is the POSH Act. Lordship, the book is not here, but this is a. Lordship kindly takes up.
What is the order that you are impugning? First, show me the impugned order.
Lordship will kindly take up the second last page of volume 2. May I place this order?
This disciplinary action.
Disciplinary action under the POSH Act, Lordship, the POSH policy of the company.
Yes.
Lordship, I had initially raised an objection regarding the constitution of the internal committee of the company. Lordship, I shall be very candid that there is a provision of appeal in the Act. There is a provision of appeal under section 18. But the point which I seek to raise before your Lordship, that is not covered within the scope and ambit of section 18. That is why I handed over the Act to your Lordship. If my Lord may kindly take it up once, then I shall take my Lord to the impugned order once. Lordship may kindly take up section 4. Section 4, Lordship, that is at page 5, bottom. This deals with constitution, Lordship.
Yes.
Kindly turns overleaf to page 6, Lordship. Subclause 2. The internal committee shall consist of the following members to be nominated by the employer, namely the presiding officer, who shall be a woman employed at a senior level at workplace from amongst the employees, provided, Lordship, I am skipping that over, not less than 2 members from amongst the employees, preferably committed to the cause of women and who have the experience in social work and have legal knowledge. C, 1 member from.
Just a minute, Mr. Banerjee.
Lordship.
You please come to the impugned order.
Lordship.
There is no such threat, as you say. They have said that you comply with the POSH Act. If there is further violation, then in that case it may lead to something which may be termination of employment.
My
So
Lord,
you have to further violate.
Lordship, subsequently, last week, Lordship, he has been served with an email that his position has been subsequently reduced. And Lordship, if he does not fit into the position in his reduced position presently, Lordship, he faces termination thereafter.
Reduced position, I didn't understand. Man. He has been lowered down in scale.
Yes, yes.
So that has already been done. Then there is, in any case, no urgency. Move it before the regular bench.
Lordship, kindly.
List this matter before the এর জন্য এসছে এটার ইয়ে আছে তো WPA বলে এসছে তো সিও না ভুল আছে এটাও সবেতেই আপনারা ভুল করেছেন এখানে there is a mistake
I tried to harp upon the land advocate. He has straightway refused to take up the revision application. I have
Opposite party, there was a miscommunication between the land advocate before the trial court, and for which he has refused to take that copy. I've been
the
instructed.
application for repairs is pending by
My lord, that is, I have not received the copy. I am.
How can
asking
he?
for
He has refused.
But tomorrow I'll kindly let them serve me a copy. Kindly fix it tomorrow.
As your lordship.
ওনার নাম লিখেন Mr. such and such enters appearance you have disturbed the bastu
চলো ওইদিকে যাও ওইদিকে
yes
On the last occasion, was directed to issue press notice upon the private respondents. আপনি কি দুজনেরই?
Now for private respondent number 8, Lordship, respondent number 7 is abroad, so he couldn't sign a wakalat number. So
what is your grievance?
My grievance is the usual landlord tenant. The landlord has locked up the room, and we are not. The CS officials are not getting access to the meter. Initially, there was that provisional system that was continuing for some time. Thereafter, they said you give me an access to that.
You have any problem in them getting the electricity supply? It
I
will
cannot
not
stand in
create
the
any right
I cannot stand in the way of electricity, my lord, but the submission is a little erroneous. The petitioner is an illegal occupant.
But suit is pending.
Let me finish, so I didn't disturb you. His father was a tenant, and the problem is the electricity meter that he was enjoying, his father, his late father. It's in the portion that I resided. Now, there is no, I do not reside in the premises as of now. It's an unpartitioned property. And the heirs are dispersed all over, and that meter board is in the position that in the place of the meter board is within my occupation. So that is the difficulty. Now, this problem arose in the year 2012. From their writ petition, I see that CAC informed them in the year 2012. And since then, they have been managing somehow, I don't know how, but till 2022, the electricity connection was disconnected because they didn't pay their dues. And this is 2026.
No,
They have come up before your lordship. Yes, so that is what has been annexed.
Are the two premises or the portion which is under your occupation and the portion which is under his occupation structurally so separate that they can be treated to be two separate buildings? No.
No, lordship. Two-story building.
Then there is a problem because
they have a separate entrance.
That is right, but the service connection, when it reaches a building and it comes out through a vent, there has to be only one service connection in one building to obviate fire hazards, crisscrossing of wires, multiplicity of wiring. Cable laying is one. It comes out through a cutout in the building, and there it is branched and several meters relating to several occupants of the building. Therefore, there is a concept of a common meter board. The meter board has to be at one common position where they only go and install a meter. This is one practice which is followed for safety reasons. Unless the building is structurally separate and there can be a separate cable line taking a separate service connection to the person's premises, where a separate line, absolutely separate, will be given. Otherwise, either from the pole or from underground, there is only one cable which enters, and then it branches into several connections, individual connections, which are metered. The service connection itself is never metered. That is main line. So if there is one main line and it is in such a position that the buildings are not structurally separate, then in that case it will be.
It seems the PSC has submitted a report. If I may take a look at I don't have a copy of the report, lordship. If there's an inspection report, and if it's possible,
the ground floor is under the.
If it's possible to have the meter installed, shifted to their portion.
Yes.
We cannot stand in the way.
That can be done.
So if
Take
I
an
may
inspection and inform if service connection, separate service connection can be
maybe a sub-meter.
There is no
or shift the meter, the existing meter.
Thing will again be amounting to giving a separate service connection. There are two types of connections. One is a loop connection, which is a branch of the service.
If the CSC authorities inspects and come back.
They are not getting it open.
My submission is that there is an outstanding due of 88.
That he will have to clear.
Will clear.
There will first inspection done with the help of the police authority in presence of the petitioner and private respondent, and we filed a report, fresh report.
Here, actually, the problem is it says that they could not enter into the premises.
Because I'm not residing there. There is no need for police authority. Lordship,
if he is put on notice, he will open it and you go and inspect.
Lordship, I am a school.
Yes, but if he is open,
I'll fix a time.
Yes, Lordship fixes the direction.
Only indulgence, Lordship. I am a school teacher, so I'm at school. So if it could be fixed on a Saturday,
yes,
I'll cooperate.
On a working Saturday, you have it. On a working Saturday, go and inspect, take inspection, and come back. Tell.
No problem. But only one submission. If police present at the time.
If I'm cooperating, Lordship,
any dispute, any arise, because landlord tenant already a suit is pending.
Necessarily not required.
Let us go for the inspection.
If he objects again, you come. I'll grant police assistance.
Oh,
next
my
time.
lord.
If I'm cooperating, Lordship, why involve the?
No, because there is a dispute, my lord.
Dispute is a civil dispute.
Said to have raised the dispute is there before the court, and he's saying that he's going to cooperate. How can I presume a dispute if there is none?
My lord, then fix a date and time also.
Yes, of course.
A Saturday, Lordship.
Saturday, a working Saturday. Can it be done tomorrow? I mean, day after tomorrow.
Give me at least, my lord, 7 days time, my lord, because CC has some
7 days time, then it may not be a working Saturday for your
No, for
officials.
first week of August, second Saturday. 8th August will be a second Saturday. খোলা থাকে তোদের?
Not today, not today.
Oh, I petition my lord. I pray for combined list, monthly list of combined August month.
My list. लिखे नहीं? The petitioner prays for an
My lord, I am appealing for the licensing company. Item number 21, I am appealing for the licensing company.
Item number
yes,
20.
21.
I'm paying for short passover.
Passed over. What we are called? Next.
But this my application is
for the state respondent.
where my lord, lordship has asked me to wait for the my lord final result of the my lord.
Now he is representing. He is appearing.
I'm for the state respondents.
Okay.
Yes, private respondent service. My lord, it's take a lot of service. Come with the current track report. It shows door locked and it is returned to me to the sender.
File affidavit of service to that effect.
My lord, since earlier occasion I have.
This also has to be brought on record by way of an affidavit of
In
service.
course of today, I will do that. But my lord, I have a judgment with that.
Who is appearing for the CSC?
My lord, I am appearing for the CSC. Actually, not today. That advocate is
My lord, this simple matter for my lord providing electricity.
Not today.
My lord, may I take back that and I will prepare that.
Next.
Really. Not working.
Yes, 23.
I am appearing of the petitioner, my lord. I paying for not today.
Not today. Next.
My lord, 24, I am for the petitioner, my lord.
Yes.
My lord, I have served everybody, but at present, the service is not with me, my lord. That is why I could not produce before yours. But I have served. But the matter is, my lord, as the electricity authority are sending abnormal bill without any meter reading, and my service connection was disconnected. That is why I had to move an application before the Honorable High Court, Calcutta, that is annexure P5 at page 19, my lord.
Page 19.
Page 19.
Yes.
And as per order of the Honorable High Court, my lord, page 22, the learned RGRO passed the order. I am agreeable with the order, my lord. Kindly see page 22. Last
Why
part one.
Why don't you prefer applications this before the ombudsman?
No, I am not agreed with the order of the learned RGRO. I am satisfied, but they have not complied. The station manager have not complied the order of the learned RGRO. Kindly see the last part one.
I have understood. I have understood. I have understood. Yes.
My lord.
Why have you not complied with the order?
That instruction I don't have, but my lord, there.
That was the only instruction you were required.
Yes, no, my lord. My instruction is, my lord, he was using, my lord, the more than the, my lord.
There is an order against you by the grievance redressal officer. You have not carried it up in appeal before the ombudsman. Why are you not complying with that?
That instruction I don't have, but I have to take it. No, kindly.
It was adjourned again. It will be adjourned.
No, my lord. I will come back with its specific instruction.
Mr. Bandopadhyay, learned advocate, appearing for the WBSCDCL authorities, seeks time to take instructions, list this matter on 10th August
My
2026.
My lord, 10th August, another matter is, my lord, kindly take it on Monday, my lord.
On
Monday,
On which-
next Monday.
next
Next
Monday
Monday,
will be
my-
monthly list. 11th will be okay for you.
No, my lord, then Wednesday.
Wednesday, 12th. 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 You come back. Again.
Yes, my lord.
21 was passed over. I was stuck before Honorable Justice Rai Chattopadhyay. I'm extremely sorry.
I've not done anything.
My lord has passed it over. If my lord takes it up, if
Let the others who have been waiting, let them have a chance then. Yes, call Kuru next.
Question which arose for your lordship's
I know,
consideration.
my lord, I and Mr. Chakraborty concluded on the next occasion.
Last
Last occasion, sorry. So far as regards the maintainability point is concerned, my lord, I want to add something so that not in reply, my lord, Mr. আমাকে দাও, judgment. My lord, what I could lay my hand, my lord, today the order that has been passed, the impugned order before your lordship, wherein, my lord, my learned senior friend has pointed out before the learned judge there are some procedural irregularities. But I have already argued with regard to Order 39 Rule 4 scope, non-service of summons, and also, my lord, what is their averment in the, my lord, application, including prejudice factor. So I am not, my lord, I am taking an alternative, my lord, argument. Even the case in hand is not only of the procedural irregularities. Their application canvasses also, my lord, the prejudice factor, which is one of the limb of, my lord, the vacating of the order under Order 39 Rule 4. But still, if we take their application to be an application only with regard to the procedural irregularities, then, my lord, two provision, my lord, I will place before your lordship. Order 39 Rule 3A, my lord, that mandates the learned trial judge, my lord, to dispose of, my lord, the injunction application within a particular period of time. If that is not being done, my lord, it is a procedural irregularities, whether under Article 227, the jurisdiction of the revisional court can be invoked. One of the judgment, I will rely on that.
Chelappan, I think, na?
That's
Chelappan is 2A, non-service.
No, 3 service.
Oh, 3 is service. Yes, yes. 3 is service. I get confused between 3A and 2A.
2 is obedient, disobedient.
2A is disobedient.
And, my lord, the second point.
Chelappan.
No, my lord,
Chelappan.
yes, Chelappan.
Yes,
It's Chelappan, yes.
That is
but I forgot the first time. Yes. I will rely one of
That's
that.
how we remember it.
Yes.
And I took me 5 years to understand that all that Chelappan said is that if you don't follow, then the order can't be enforced. Contempt won't lie.
And the appeal becomes an appeal in the eye of law, because it was a more strict reading of Order 39 Rule 1 and 2, where it said that, in a sense, ex parte stage appeal may not be maintainable. That is
Yes,
one way of
that is
reading
one.
it.
Yes.
That is one way of
Appeal would be maintainable.
it will be maintainable if 30 days pass and
the judge hasn't.
Yes.
But then that has been mellowed after, because
And, my lord,
ex parte stage, if you hold appeal not maintainable in all cases, then
That's the end of the story.
The appeal court will
Finished.
Yes.
will be at sitting idle, and the revision courts
Yes,
will be
the
flooded.
floodgate will open. My lord, this one way or the other, we can
So
approach.
that is why very guarded language is there.
Yes.
Ordinarily and all.
I will rely on this judgment, and also I could lay my hand, my lord, in one of the Andhra Pradesh case, wherein the 148 capital A, my lord, the non-service of the copy or rather notice prior to moving the or rather obtaining the injunction, my lord, ex parte, that was taken into consideration. The court said
148A,
my lord, the caveat
service.
My lord, there was a case where there was a
They
caveat.
have held that to be mandatory.
No, yes, my lord, that's where the court is saying that yes, it may be an irregular order. My lord, today the court has taken into consideration that 148A, a validly lodged caveat is there. No notice was served. Order is being obtained ex parte, as if, my lord, the case in hand. The jurisdiction is being invoked under Article 227. The court said it cannot be said to be an order without jurisdiction. It can be said to be an order passed by a learned judge wherein some procedural irregularities are there. Suppose, my lord, today your lordship sitting under Article 227, if noticed that a passing of case wherein the district judge to have the jurisdiction and a civil judge junior division is passing an order of injunction. definitely, my lord, your lordship under Article 227 can exercise your lordship's jurisdiction, since the order passed is a nullity, is a patent irregular exercise of jurisdiction. So the court has categorized two different situations. So the court said, even if there is a procedural irregularities like a notice is not being served under 148A, caveat is being lodged, then also it cannot be said to be an order without authority. It may be said to be an order which has been passed.
Chelappan will then in one way be against you also, because then this but this was not an ex parte order.
That's Lord, I shall place both these
not
two.
only for ex parte. Chelappan was until it is disposed of. So if it has not been disposed of, it does not have an appellate remedy.
No, my lord, today his application, no, my lord, today his application is, my lord, Chelappan is a case wherein directly, my lord, no, my lord, vacating application is being filed or recalling application, whatever way your lordship takes. But today the case in hand, there is an application filed by them, inter alia praying for, my lord, recalling or vacating of that order. That has been dealt with and an order has been passed. More so, I will say, this cannot be, my lord, interfered under Article 227. In my, today I am restricting only, my lord, with regard to maintainability. May I not place, my lord, 2000 volume 7 first, 2000 volume 7 Supreme Court cases, my lord, page 695.
Yes.
But may I place only some portion of the facts? Thereafter, we will take your lordship to the operating portion, rather the ratio of the judgment. The paragraph 2, when a plaintiff, has your lordship got it? When a plaintiff rushed to the civil court for an ex parte interim order of injunction against some of the defendants and obtained it, those defendants rushed to the High Court to get the order quashed. So, the High Court, both parties succeeded in their respective endeavor, and now both of them accused each other for the course adopted by the other. This appeal is by way of special leave at the instance of the plaintiff. So, the facts are get clarified over here. Now, kindly takes up the paragraph 9 scope of Article 227 and section 104 of the Code of Civil Procedure is being quoted and narrated, paragraph 9 and 10. But I will not disturb your lordship. Paragraph 12 also, the Order 39 Rule 1 is being quoted. Now, if your lordship takes up straight away, to paragraph 15. What would be the, what would be the position if a court which passed the order granting interim ex parte injunction did not record reasons thereof, did not require the applicant to perform the duties enumerated under clause A and B of Rule 3 of Order 39? In our view, such an order can be deemed to contain such requirements, at least by implication, even if they are not stated in so many words. But if a party in whose favor an order was passed ex parte fails to comply with the duties which he has to perform as required by the proviso quoted above, he must take the risk. Non-compliance of such requisites on his part cannot be allowed to go without any consequence, and to enable him to have only the advantage of it. The consequence of the party who secured the order for not complying the duties he is required to perform is that he cannot be allowed to take advantage of such order if the order is not obeyed by the other party. A disobedience beneficiary of an order cannot be heard to complain against the disobedience alleged against another party. The learned single judge stated that the trial court ought not to have granted ex parte injunction beyond 30 days to be enforced. The said observation is based on the language of Order 39 Rule 3A, that has been quoted. Now, 17. The rule does not say that the period of injunction order should be restricted by the court to 30 days at the first instance, but the court should pass the final order on it within the 30 days from the day on which the injunction was granted. Hence, the order does not ipso facto becomes illegal merely because it was not restricted to a period of 30 days or less. Nonetheless, we have considered the consequence, if any, on account of the court failing to pass a final order within 30 days, as when not 33 capital A. Now, my lord, if your lordship takes up the next paragraph, the aforesaid rule cast three prolonged protection to the party against whom an ex parte injunction order was passed. First, the legal obligation that the court shall make an endeavor to finally dispose of the application of injunction within the period of 30 days. Second is the legal obligation that if for any valid reasons the court could not finally dispose of the application within the aforesaid time, the court has to record the reasons thereof in writing. What would happen if the court does not do either of the courses? We have to bear in mind that in such a case, the court would have bypassed the three protective humps which the legislature has provided for the safety of the person against whom the order was passed without affording him an opportunity to have a say in the matter. First is that the court is obliged to give him notice before passing of the order. It is only the way very exceptional contingents that the court is empowered to bypass the said protective measures. Second is the statutory obligation cast upon the court to pass the final order on the application within the period of 30 days. Here also it is only the very exceptional cases that the court can bypass such a rule, in which cases the legislature mandates on the court to have the adequate reasons for such bypassing and to record those reasons in writing. If that humps in also bypass the court, it is difficult to hold that the party affected by the order should necessarily be to the sole sufferer. It is acknowledged position of law that no party can be forced to suffer of the inaction on the part of the court or its omission to act according to the procedure established by law. Under the normal circumstances, the aggrieved party can prefer an appeal only against an order passed under Rule 1, 2A, 4, and 10 of Order 39 of the Code in terms of Order 43, Rule 1 of the Code. He cannot approach the appellate or revisional court during the pendency of the application for grant or vacating of the temporary injunction, where I am on, Milord. It's not a stage where it's pending. In such circumstances, the party does not get justice due to the inaction on the court to following the mandate of law must have to be remedied. So, Milord, if the court keeps aside the vacating application, goes on, Milord, extending the interim order, yes, the law is let down. So where are the view of the cases where the mandate of Order 39 Rule 3A of the Code is flouted, the aggrieved party shall be entitled to the right of appeal, notwithstanding the pendency of the application for grant of vacating of the temporary injunction against the order remaining in force. In such an appeal, if the preferred, the appellate court shall be obliged to entertain the appeal and further to take note the omission of the subordinate court to complying with the provision of 3A. Pausing here for a moment. So the court is let down to procedure. If the court goes on mechanically extending the interim order, keeping aside the application for vacating pending, then also the court is saying, yes, the doors of the appellate court is open. And here, Milord, on the contrary, their application for vacating or whatsoever, Milord, recalling application that has been considered, taken out, order passed on merit, and simultaneously, Milord, extending the interim order. Now, Milord, takes up, Milord, paragraph 22. Now, what remains to be questioned, whether High Court should have entertained the petition under Article 227 of the Constitution. Under Article 220, now the court is considering whether the 227, because here is the case where, Milord, the initial order of injunction is passed, directly 227, order reversed under Article 227. Now the Honorable Supreme Court is saying, now paragraph 22, Milord. Now what remains is the question whether the High Court should have entertained the petition under Article 227 of the Constitution when the party had two other alternative remedies. Though no hurdle can be put against the exercise of the constitutional power of the High Court, it is a well-recognized principle which granted judicial recognition that the High Court should direct the party to avail himself of such remedies, one or the other, before he resorts to a constitutional remedy. Learned single judge need not have entertained the revision petition at all, and the party affected by the interim ex parte order should have been directed to resort one of the other remedies. Be that as it may, now it is idle to embark upon the aspect as the High Court has chosen the entertain the revision petition. Now, my lord, the paragraph 23, the Honorable Supreme Court is reimposing the order of status quo. So it was there ad interim, vacated under Article 227. The Honorable High Court is reimposing that and remitting the matter back for fresh consideration. So, my lord, in my respectful submission, the case in hand before your lordship is not in either way to invoke the jurisdiction under Article 227. Because had it been a case that their vacating application, keeping aside pending the learned judge exercise the jurisdiction, then also the Honorable Supreme Court is saying the door of the appellate court is open. Yes. Now, my lord, এত খারাপ বলছি?
না 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 একদম you're arguing very well.
But only another aspect, since the case in hand is under 148A, non-service of notice or copy. Lord, may I rely upon AIR 1981 Andhra Pradesh, page 246. তোমার কাছে আছে তো?
কোনটা? হ্যাঁ এগুলো সব বার করা হয়েছে।
Here, my lord, I am not troubling your lordship regarding
Last
the.
day you had only cited two unreported cases of
I could not, my lord, lay my hand, my lord, on the last occasion when I argued regarding a case where 148A creating a problem that there is a valid lodging of caveat allegedly and non-service of notice. But here, my lord, I think, my lord, this has been taken note of. Lord, here is a case, Lord, I must be candid before your lordship. What happened? Lord, if order section 148 capital A, your lordship looks at, there are two simultaneously duty casts. One is against whom the caveat is being lodged, who is intending to file an lord application before the court for obtaining any interim order. What is that duty? That if you want to take an order by filing an application and a caveat is being lodged against you, you have to serve a copy to the other side. Simultaneously, if your lordship takes up subsection 3, then there is a duty cast upon the court also that if you look that there is a valid lodging of caveat notice there, the court prior to hearing of the matter should give a notice to the other side. So there are two simultaneously duty cast blood by the provision upon the court as well as blood the party against whom the caveat is being lodged. One of the glaring mistake that has been noticed in the case in hand, which I am citing before your lordship, that though the copy is being served, but when the matter got transferred to other bench, the learned judge could not serve notice, rather ignored that lodging of caveat and takes up the hearing in absence of the other side, though there was a caveat and an interim order was passed. Challenging that, the 227 application is being filed before the High Court. So that's the fact, my lord, I must
of this case.
Now, my lord, if your lordship takes up paragraph 4, my lord, the entirety of story is being narrated. I am not troubling your lordship regarding that.
এগুলো this is in your favor.
Lord, now takes up the fourth page of the fifth page of the order.
Fourth page.
Fourth page, paragraph 4, last paragraph, may I place before your lordship? The duty of the court. The duty of the court under subsection 3 is in addition to the other parts assigned by the other parties in the drama of litigation. The furnishing of copies of the document by the plaintiff to the caveators on such and such and informing them of the date of their moving interlocutory application cannot therefore be taken as acts constituting compliance with the specific duty assigned to the court under subsection 3 of section 148 capital A. The duty of the applicants under subsection 4 of section 148A is different and distinct from the duty of the court under the subsection 3. I therefore entertain no doubts whatsoever in holding that the lower court had erred in passing the impugned order of injunction on 30th October 1980 against the caveators without giving them a notice of the date of hearing. If that is all, I would have allowed the CRP without anything more. But unfortunately for the petitioner, there is a lot more to be said against them in this case. The precise question that is now raised is whether the aforesaid failure of the court to act in accordance with the requirements of subsection 3 of section 148 capital A is a failure relating to its jurisdiction or merely its procedure. If it is a jurisdictional fault, the order passed by the court ignoring the requirement of subsection 3 of section 148 capital A would be a void order and would not be allowed to be operative for any purpose. On the other hand, if it is a procedural error, the order stands still. It is set aside in an appropriate constituted legal proceeding. Now, my lord, the word caveat is being, my lord, explained through the dictionary meaning paragraph 5. Now may I place, my lord, paragraph 5, the dictionary meaning. The English law gives the meaning of the word caveat is an entry made in a book of the officers of a registry or a court to prevent a certain steps being taken without previous notice to the person entering the caveat, who is called the caveator. What appears to me to be significant from the above two meaning taken out from the two well-known legal dictionaries is the fact that none of these standard words puts the caveat so high as to act as a fetter on the exercise of the power of the court. In other words, they do not say that any action taken by the court without giving prior notice to the caveator would be a nullity. The reason seems to me to be that the caveat has no effect on the exercise of the powers by the court. It follows, therefore, that the order passed by a court without giving notice to a caveator cannot be treated as a nullity. If statute intends to demolish the ordinary power of a civil court, it is well settled proposition of law that it can only be done by a direct piece of legislation enacted for the purpose and not by a effect of an indirect legislation as if it were by a side wind. The powers of the civil court are too sacrosanct to be allowed to be diluted or to be curtailed by a mere remote implications. I therefore hold that as there is no specific provision declaring any action taken by a court contrary to the mandatory duty under subsection 3 to give notice would be void, the order passed by the court below dated such and such is not a nullity. In other words, it appears to me that a mere lodgement of a caveat would not deprive the court of its power to pass an order even if caveators was not informed of the date of hearing of the matter. As the lodgement of the caveat is merely a right to be informed of the hearing date, and it is no effect by way of curtailing the power of a civil court to pass an appropriate order on the merits of the case. I hold that the order passed on such and such is not without jurisdiction and is therefore operative till it is set aside in an appropriate proceeding. Now, my lord, paragraph 6 is regarding power of. Now, my lord, then my lord 115, now 227. This leads me to consider the question whether the present revision filed by section 115 of the Code of Civil Procedure is an appropriate proceeding. It must be noted that against an order of injunction passed by the court below, the Order 39 Rule 1 of CPC, the petitioners have a statutory right of appeal under Order 43 Rule 1R of the Civil Procedure Code. Under section 115(2) of CPC, the High Court is debarred from varying or reversing any decree or order against which an appeal lies either to the High Court or to any court subordinate to it. As I hold that the order passed by the court below is one passed not without jurisdiction, it follows that the order dated such and such is an appellable order, and therefore cannot be interfered with in a revision. Similarly, I, my lord, respectfully submitted, my lord, in both ways. If your lordship takes up their gamut of the application, it's really not only restricting to recalling. Once they pleaded the facts of prejudice, it's really invoking the power under Order 39 Rule 4. And if it is really an application for vacating, variation or modification, then, my lord, it comes under the purview of Order 43 in whatsoever way. And this order is, my lord, coupled with two things. First, my lord, exercise of power under Order 39 Rule 4, coupled with not extending the interim order. So if we take 2000 volume 7 as well as this case in hand, then in both ways, they cannot invoke jurisdiction under Article 227 because their remedies are open.
Our court has differed on this point. The Andhra Pradesh High Court says it is not a jurisdictional defect, but our court says it is a jurisdictional defect. Non-service of notice to the caveator is a jurisdictional defect. That is what has been relied on by Mr. Rai and Mr. Chaudhary on the last occasion, the division bench judgment of unreported division bench judgment.
Earlier round of litigation?
No. Yeah. Last time when it was taken up, when they started, they placed division bench judgment Gayatri Chetna Foundation.
Gayatri Chetna, my lord, we relied on.
Achha, you relied.
Yes.
There,
my lord, I argued also with Mr. Chatterjee. They are also, my lord, your lordship will, my lord, find this is an appeal, my lord, under Order 43.
Right, but it has been held to be a jurisdictional defect.
I say, my lord, respectfully, my lord, jurisdictional defect, exercise of jurisdiction, my lord, whether it's a nullity It's not that has not been laid down as a ratio of the judgment.
No, it has been in a sense so that you can answer it. If you come to paragraph 41.
Gayatri Chetna ka agar mein subah se hai. Hey, Gayatri Chetna ka agar mein. Gayatri Chetna. Yes,
you don't have a copy. Check
This
my
copy, this
If
copy,
you want
there
it.
is 47.
Yes,
Take paragraph 41.
আর এটাও দেখে নাও।
Paragraph 41.
And your judgment has been considered and not followed in Guwahati High Court.
Caveator, non-service of prior notice on the caveator. Just before that, we are inclined to set aside
Yes,
due to
Lord.
dearth
We
of
have
jurisdiction.
clarified that we have not entered into it.
Dearth of jurisdiction. That means no jurisdiction.
Trying to set aside the same due to the dearth of jurisdiction.
Plus, there is another learned single judges. These are division bench judgment. Learned single judges judgment entertaining revision.
But this, in my respectful submission, the learned division, the honorable division bench is setting aside the order, the injunction order, due to dearth of jurisdiction for non-service of prior notice. So it's not the order is patent illegality. This is also a procedural irregularities.
No,
The
but it says non-service of notice despite caveat means no jurisdiction to hear. That is what the order leads to. You will, in a case where there is no caveat, you have jurisdiction to hear and pass orders. In a case where there is caveat, this is my prima facie understanding. In a case where there is caveat, your jurisdiction to hear and pass orders will come only if notice is served and not otherwise. That is what the meaning is. Therefore, if you have exercised jurisdiction which you don't have at that point, for example,
suppose today, the court has been faced with such an exigency that, in my respectful submission, that even this service of notice, this will take some time. This service of notice itself, creates the matter, or rather renders the matter infructuous. What, the Honorable Andhra Pradesh High Court has dealt with, the power of the civil court has not been curtailed. It's a procedure that has been laid down. On the contrary, what is falling from your lordship, that once a caveat is being lodged, the jurisdiction of the court is being ousted. There is no enabling provision to that.
It is ousted to pass an order without hearing him.
That's where I am on. Today, suppose, something is happened that if the order is being not passed, 12 noon, 12 plus 5, the matter will going to be infructuous. The court is faced with such a situation. And there is a lodging of caveat. In my respectful submission, the court is not denuded with the power that the court will not entertain or not pass an order. What has been faced with the Honorable Andhra Pradesh High Court, that's where the enabling provision is not there, curtailing the power of the court under the Code of Civil Procedure, that has been extensively dealt with by the Andhra Pradesh High Court and said, no, it's maybe a procedural irregularity for which the party who is suffering the order, he is not left with remediless. The remedies are being provided. Either your lordship under Article 227 or the subordinate judiciary under Order 43. The power is there.
In this case, there was no recalling application. In this case?
No. In the case in hand, Gayatri Chetna, there was no recalling application. They're challenging the ad interim order directly comes up in a first miscellaneous appeal under Order 43. So that point was not taken into consideration in my respectful submission. That was not even German issue involved over there. Because they have not invoked under Article 227.
I'll just quickly show your lordship, Milord. And then I have an argument which is independent of the judgments. Milord, first, this is Milord 90 CWN. No. Milord, this was a revisional application. And Milord, on the same issue. The middle of the first paragraph, it appears from the order itself that anticipating the fact plaintiff asked for order of injunction, defendants lodged caveat, Then endorsement on petition. Wrong endorsement. Assistant registrar made an endorsement for no caveat. In the result, plaintiff obtained identity order ex parte. They filed an application and then revision filed. Yeah, it's that one. Filed an application indicating the irregularity. End of first paragraph. Application was disposed of, which is the order impugned in the present revisional application. In the first 4 lines, no denying the fact that there is no caveat. Rules of caveat meant to give opportunity. If, as in the present case, caveat was actually lodged before the order was sought for, as has been found by the learned judge, he could not still proceed to say that he would proceed on the erroneous endorsement of the assistant registrar. Only course open to the learned judge should have been, when such defect was pointed out, to recall the order forthwith and rehear the matter on contest. This would be the procedure followed to fulfill the real object of the rule of caveat. We are therefore unable to sustain the order passed by the learned judge on 2nd April. We set aside the order. We allowed the application, recall the ad interim order and direct. Now, my lord, this was considered. It is out. Calcutta High Court. This was, my lord, considered in another. This is a division bench not considered in another division bench judgment of this honorable court.
This is
Copy
the
the-
Gayatri Chetna, which
Yes. I gave him an unreported copy. A same judgment. Manoj Joshi. I give you the SCC copy. Say SCC copy now.
same both.
Yes. My lord, argument. That
And Mr. Chaudhary, you argue on merits also. You
Yes.
so that
Absolutely.
he can
No,
holistically-
immediately, my lord.
He will reply holistically to both, and after that, if you want to rejoin on merits, you can read.
Yes. My lord, paragraph 23.
23.
Then, my lord. Paragraph 34. Now, please see, my lord, paragraph 34, second line. Under such circumstances, it was mandatory for the court. Then, my lord, up to 37. There are 3 things I want to stress on, my lord. Mandatory for the court. Next, my lord. Next page, first sentence. There is no window of exception for avoiding notifying the caveat or
On the ground of urgency.
yes, my lord. Then, my lord, only paragraph 35, last 3 lines, only recall, only, my lord, recourse was to recall the order and rehear the matter. Recall. So, my lord, that's again something I am not stressing on. Now,
When
my
is
lord,
the matter returnable? In December, you said, no?
yes.
That, my lord, I am
No, that's my-
agreed to
My
report,
learned
lord.
friends,
I cannot,
I
lord.
am told, my lord, he's got a very strong legal team.
No, my lord, I can, my lord, give.
Their powers of
I have taken
persuasion.
instruction, my lord, that your lordship can prepone it. There is no difficulty on that. That's the diary of the court, my lord. We have nothing.
My lord, now, my lord, this is 2014. 2014 Courts THN 263 revision application following 90 CWN. Paragraph 3 facts. Then below paragraph 590 CWN considered. And paragraph 9, Milord, recall of the order is the only option. And CO, Milord, entertained. Now, Milord, PIR 94 Guwahati, page 7, which is, Milord, also there on ACC online. Here, Milord, same facts, but Milord, whether Article 227 intervention is warranted, Milord, is considered. Now, please see paragraph 7. Important question of law which arises for determination is whether petition against appealable order is permissible under Article 227. Lord, I am omitting arguments. Lord, please come to page 265. Lord, page 265, just before paragraph 15, after going through judgments, final consensus is that extraordinary jurisdiction can be invoked where there is violation of fundamental basic principles of justice and fair play, patent or flagrant error. Will kindly note this because I'm going to develop this argument. Error in procedure of law resulting in injustice. Then, my lord, paragraph 18 is on object of caveat. Paragraph 18 on the next page. And please, my lord, see page 267, paragraph 19. To sum up, where court or tribunal passed an order without jurisdiction and to violate basic fundamental principles of law, or where a patent or flagrant error in procedure has been committed, High Court can intervene under 227. In a suit like case of present nature, caveat was not receipt of notice duly filed in court, ad interim injunction granted without notice of hearing would be ordered without jurisdiction. Therefore, maintainable. And paragraph 20, my learned friend's the judgment which is cited is distinguished. The Andhra Pradesh judgment is distinguished. Milord, that judgment, if your lordship sees, while I am at it, Milord, kindly take my learned. What? Kindly see that judgment, Milord, once. Page 4. Bottom. I was prompting my learned friend. The question was, is it a void order or is it a procedural error? Page 4, my lord. Then, page 5, third paragraph, court says it cannot be treated as a nullity. Paragraph starting with Jowitt's dictionary, middle, my lord, at 10 lines down, it follows therefore that order passed by a court without giving a notice to caveator cannot be treated as nullity. My lord, no order of any court can be treated as nullity. And therefore, my lord, paragraph
Unless
6
it is without jurisdiction.
Yes.
It can be treated as nullity if it is without jurisdiction.
Yes, but court has to say so.
Yes, of course.
My lord,
I cannot say that an order is a nullity.
I cannot say.
It has to be declared.
It has to be declared by court.
It has to be declared.
That's the difference from an administrative act. If it's an
You cannot put the stamp of invalidity on the head of an order.
So therefore, the question posed by the court that if it's not a void order, it is not without jurisdiction is wrong. Contrary to, my lord, findings of our court, contrary to, my lord, findings of Guwahati court. Judgment has never been followed. Now, my lord, I want to also quickly create a distinction. There is an order on merits or, my lord, determination of the facts of a case and an order passed by a court. There is an order, that's not one. Two is an order passed by a court using its inherent procedure, inherent power under 151 for regulating procedure, for recalling, for adjournment. Your lordship would not think back, even tribunals, quasi-judicial bodies directed to hear matters have certain inherent powers. It are these inherent powers which is used for the purpose of regulating procedure, recall, adjournments, giving a date, not giving a date, etc. So, my lord, these inherent powers are there for the purpose of doing justice. This is what is known as procedural review. So, I see something wrong procedurally happening. I, as a quasi-judicial body, recall the order. I see adjournment is necessary, I grant an adjournment. This is inherent power in every adjudicating authority, even lesser than court, not having trappings of court. So when that's why this is processual review, and even when the statute doesn't confer power of review, that court has the power to do procedural review. So procedural review is different from substantive review, different from merits. Procedural review is to do justice and using inherent powers present in every court and tribunal. If I was not on merits on my application, only remedy appeal. But no, I am not on merits. I am on regulation of procedure. Prayer will not limits it to say recall the order because of 148A. So therefore, I am only invoking that processual review for recall using inherent power of court. And my only option is your lordship under 227. Two quick judgments, on this. This is really beyond the argument, the judgments. 1980 supplementary SCC 420. Labor tribunal setting aside an ex parte order.
Recall is different than review.
Recall is different than review. And this is the parent case, that Greenley's Bank case. This leads to tough drilling of the Supreme Court, which says even arbitrators have these powers. This is inherent in everybody. From the other high court
was ultimately the 2018, that Shrey case.
Yes,
Bhushan reinstated.
Tough delay. I remember. In fact,
recalled the order.
I must
say it had not become functus officio yet. That was the
2 years we had not moved before Mr. Bhaskar said. Your Lordship visited for the portrait I am leaving. I went and said that don't dismiss my claim. His Lordship was pleased to dismiss my claim. But you haven't taken steps in 2 years. File 227. Mr. Sen also said, I don't have the power to recall that order. I had already dismissed. I said, no, you do. Because this is there in every adjudicator. We went before Justice Tandon under Article 227, succeeded. Then succeeded in Supreme Court. So, this was cited in that matter also. Kindly, see paragraph 4, 6, 10 and 13. 4 for the facts, 6, my lord. Tribunal had power to pass impugned order in the interests of justice. 4 lines down, well-known rule of statutory construction, tribunal or body should be considered to be endowed with such ancillary or incidental powers as are necessary to discharge functions for the purpose of doing justice. This is that power. Now, my lord, 10. Regulation of procedure, and 11. And then, my lord, 13. The distinction, my lord, 13 is really important. The distinction between procedural and substantive review. Procedural review is done under inherent powers. So, my lord, this is the procedural review termed as a recall. And this, my lord, is considered, this question is also considered in 2005 13 SCC 777. My lord, I'll just read out one sentence from paragraph 13 of the earlier judgment. My lord, middle of paragraph 13, the expression review is used in 2 distinct senses. Number 1, procedural review, which is either inherent or implied in a court or tribunal to set aside a palpably erroneous order passed under misapprehension and review on merits. And procedural review is inherent part. Now, my lord, 5005 13 SCC 777, para 18 and 19. Look, please see para 18, the earlier judgment is considered, then para 19. So these are all cases where review is not permitted by statute. For the quasi-judicial authority, it has no, my lord, power to review. But this branch of recall is exercising an inherent power of every adjudicator. Now, please see para 19, 4 lines from the top. Procedural review belongs to a different category. In such a review, court or quasi-judicial authority having jurisdiction to adjudicate proceeds to do so, but in doing so commits a procedural illegality which goes to the root of the matter and invalidates the proceeding, consequentially the order. Cases where a decision is rendered by a court or judicial authority without notice to opposite party or under mistaken apprehension that notice has been served, or where matter is taken up for hearing and decision on a date other than the date fixed for hearing are illustrative cases in which procedural review may be invoked. In such a case, the party seeking review or recall of the order does not have to substantiate the ground that the order passed suffers from error apparent on the face of record or any other ground which may justify a review. He has to establish that the procedure followed by the court or quasi-judicial authority suffered from such illegality that it vitiated the proceeding and invalidated the order made therein, inasmuch as the opposite party concerned was not heard for no fault of his, or that the matter was heard and decided a date, etc., etc. In such cases, therefore, matter has to be reheard in accordance with law without going into merits. Or the order passed is liable to be recalled and reviewed, not because it is found to be erroneous, but because it was passed in a proceeding which was itself vitiated by an error of procedure or mistake, which went to the root of the matter. So this is not inherent power. Now, my lord, if you, which one? I want to. Just one sentence from a Supreme Court judgment. Though, my lord, the division bench, my lord, we have placed paragraph 49 of this judgment. It just says following a caveat is mandatory. My lord, page 338. Second line, in law, the rights of a caveator are different from cross-objectors per se. In terms of section 148A of the code, caveator has a right to be heard mandatorily for the purposes of passing of an interlocutory order. Law contemplates that caveator is to be heard by the court before any interim order can be passed against him. Same thing, what our division bench says. Done. Now, my lord, please see very quickly, my lord, please see the application at page 94.
I can reply on the maintainability issue.
No, 1 minute. Let me just quickly, 5 minutes. I have only taken 10 minutes, just 5 minutes.
Once he is done, you can.
Very well,
if
as your lordship.
you cannot
Well,
complete
since
today,
it's-
come on the next day and do it.
Very well, very well.
Yes.
My lord, heading, application for recall or vacation, recall, page 94. My learned friend, my lord, is the blessing. The danger is my other learned friend, Mr. Srijit Chakraborty. I am very scared of him.
Everyone.
Yes. The problem is, again, my lord, problem is not with Mr. Chakraborty. Problem is with Mr. Aniruddha Chatterjee. So Mr. Chakraborty went to the wrong chamber.
He is not there.
All problems in life lead to Mr. Aniruddha Chatterjee.
Mr. Mukherjee will surely inform him of this.
Yes, I will.
He will. Suppose he will go over there.
Now your lordship will miss this. Adjudicator of this dispute between me and Mr. Chatterjee is not any of your lordships, but the Prabhu.
Yes. We can't avoid it in any manner.
That was always in front of this court only.
Yes.
In front of the bench, by the
Yes.
side of the staircase.
Milord, which is why, Milord, these are lucky courtrooms.
Yes.
But
Just below the board.
Yes.
Maximum
But
of
what
the time when we
justice-
were not in courts, we were there.
Milord, because he is there, the boards keep moving. And what Justice Shampa Sharkar said is also very, Milord, important. He said that even if you are the Prabhu, you have to say my lord to us. Though nowadays he's getting angry. Milord, please see page 94, application for recall, paragraph 2, caveat, paragraph 4, caveat, paragraph 5, caveat, paragraph 6, caveat. It's all on caveat. One paragraph 9, but that's on something else. But Milord, please see the prayer. Prayer is very limited. Prayer is page 97. A, recall and vacate the ad interim order of injunction dated 21st February 2026 in TS number 105 against the defendants on the ground that the same has been passed in flagrant violation of mandate of 148A without notice. So, my lord, it's limited to that. Because of the way my learned friends have crouched the prayer, it's, my lord, limited to section 148A. Now, my lord, please see the impugned order. Yes, I'll just show one more, then Milord, my learned friend Milord will take over. Page 5, Milord. Can't be page number.
101, paragraph 5. Was it part number 1?
Huh? Yeah.
Sorry, petitioner number 1.
All of the petitions. We are appearing together. Milord, this is something I also want to show your lordship. Page 5 of the order. Now the learned judge, Milord, after it goes back, says something, Milord, which is not correct. The learned judge says in subparagraph 6, now the court is of the considered view that the said caveat 1897 should have been filed with proof of delivery of the notice in view of the fact that activities of caveat number such and such is governed by the amended provision of 148A of CPC, which came into force 4 days before filing of the caveat. Now, this is important. Milord, please see, Milord, section 148A. It is a recent amendment.
This is annexed also, page 55. Page 55.
Oh, Milord, it's annexed, page 55.
It has been annexed, but just has to be notified.
The amending act is, Milord, annexed.
Annexed to the petition?
Yes,
yes.
Act? Yes. To make it, Milord, to bring the amendment to your lordship's notice.
Page 55.
Because what the learned judge says is that you have to dispatch, get proof of delivery, and then only can you lodge a caveat. So then no caveat will ever be lodged.
No, that is contrary to CRO. 48.
Yes. Milord, please see page 73.
Page 73.
Yes, this is 73 is the repealing and amending act of 2025.
Yes.
And page 77,
the code of civil procedure, act number 5.
section 148A is not amended. And what does it say? It says
subsection 2 was amended.
Yes. It says that for the words registered post acknowledgement will be the word speed post with registration and proof of delivery. Now, Milord, if you're, I haven't found a book, I haven't found a book with the amendment. If your lordship takes the old book, Milord,
to compare it.
148A. So where Milord, kindly see, Milord, the old subsection 3. Milord, subsection 2, I'm sorry, Milord, my mistake. Milord, it used to read, where a caveat has been lodged under subsection 1, the person by whom caveat has been lodged, hereinafter caveater, shall serve a notice of the caveat by registered post acknowledgement due. Now it is
registered post acknowledgement due, it has become
speed post with registration and proof of delivery.
So proof of delivery was there even otherwise before the amendment. Only the mode has changed.
Acknowledgement due has changed.
Acknowledgement due is proof of delivery. What else? The acknowledgement will come only if it is served. But cannot have an acknowledgement.
But learned judge below, learned court below says that because of this amendment, you have to give a proof of delivery of caveat before you lodge it. That's absolutely incorrect. Please see the impugned order.
40A. How does lower courts whether there is any provision?
First the impugned order once, Milord. Subpara 6 on the 5th page. First, the learned judge sees that there is a mistake. Then says your caveats also bad. Please see 6. Now the court is of the considered view that caveat 1897 should have been filed with proof of delivery of the notices in view of the fact that activities of caveat number such and such is governed by amended provisions of 148A. This is totally wrong. Please take section 148 capital A once. Lodging of caveat is subsection 1. Where an application is expected to be made, any person claiming right to appear before the court may lodge a caveat. Then 2, where a caveat has been lodged, so I've already lodged. 2 comes into operation after lodging of caveat. I now have to file proof of delivery. So learned judge will not put subsection 2 before subsection 1 or with subsection 1 or actually before. 1 says lodge, 2 says after lodging give proof of delivery. Learned judge will not puts 2 before 1 and says get proof of delivery first, then go and lodge. That's the mistake. And civil rules and orders is also very clear.
But which one will prevail? CRO or CPC?
CRO. Lower court proceedings were regulated by the subject
But I must say,
CPC should prevail. How can CRO?
CPC will prevail for the procedure, but the procedure to be adopted, how the procedure, a caveat to be lost. What is the procedure to be adopted?
But that has to be subservient to.
Yes, that is not considered. That is not considered.
No, but there is no conflict.
There is no conflict. Unless there is conflict, the CRO, because of the application rules, said Manar Kali considered. While we are filing appeal, now my degree is not necessary for filing of the appeal. If you are logically considered order 41, what to be annexed? Judgment. But we have, before moving that for admission hearing or like that, the degree required to be, but it is not mandatory filing of the appeal, degree is mandatory. So thereby the appellate side rules has not been changed. So it is not.
No, because for the High Court's appellate side rules have been given precedence over CPC.
CRO to that effect, when it is a prepare under the.
But I have doubt. CRO for the subordinate courts.
My understanding
trial courts will not prevail over CPC.
No.
Appellate side rules prevail over CPC because that is High Court has framed. Original side rules will prevail over that because that is High Court.
Civil rules are also framed.
Yes, but those will be subservient, not.
Unless there is conflict.
No, there is no conflict because it on the issue at hand, it says exactly the same for Rule 40A. It says exactly the same.
CRO.
Only conflict now is it says registered. This still says registered post.
Only this is
only that's the conflict.
So that will prevail.
That's only the mode.
Yes.
Only the mode has changed. The result.
Otherwise, rule of caveat is I lodge caveat, then I serve, then proof of delivery I file in court.
Yes.
Learned judge says you get proof of delivery before you lodge caveat. That's the mistake in the order.
That can't be.
That will defeat the purpose.
How caveat has been lost in this present proceedings?
So that's the finding, my lord, which I showed your lordship in subpara 6. So but this is the incorrectness in the order. My lord, please see subpara 4. Thus, post 20th December 25, only sending notice is not sufficient for survival of caveat. Such sending should be accompanied by proof of service to make and keep the caveat alive. And then 6, this is the complete.
Sending with proof of service doesn't make sense because how can you send with proof of service? You have sent, somebody will receive only, then there will be proof of. How can you send with proof of service?
No, what he says, I think, is I sent with proof of service.
It comes,
then
then
comes back. Then I go and lodge along with by that time suit filed, order obtained.
না এইখানে ক্যাবিনেট লস জন্য how the cabinet lost in the instant
My learned friend would say something on the order. Issue. Issue না শেষ করো এই অর্ডারটা ভালো করে তুমি বলতে চাইছি ওটা দেখো
Yes, Mr.
Now, before your lordship, my learned senior friend have already argued some of the benefit points. I only draw your lordship attention to the order passed by your lordship on the earlier occasion. And turn to page 203.
What is wrong with that?
201. Huh?
ওইটা আগের বারের অর্ডার
Yes.
Paragraph 5. This is my assertion. Now, my lord, what was the reply to such assertion, my lord? Your lordship can turn to page paragraph 6. It was a specific case made out by the opposite party in there that was not brought to the notice of the court. So how it can be said that the court did not recall that order? And how we could say that court cannot recall, will not recall that order? Concerning the same, my lord was pleased to find that he filed an application to that sense because that application was filed, that was paid deed. That is why your lordship was pleased to direct. Now man can turn to 204. Paragraph 10 and 12 is a specific. What more court has to be satisfied that the wrong has been committed and that request to be undone.
Paragraph 12 was there.
It is their case, it was not brought to the notice of the court that a caveat has been lost. That is why your lordship was opinion already there and application has been filed. Just place this application on the next date and that it is specific direction of the Lord trial court to consider the said application in the light of the judgment reported in Shukumar Rai. Where it says, as soon as it comes to your knowledge, there is no other option to recall that order. Then whether the court is on the apprehension that order be recalled and wanted to protect it or due some other reason, I don't know, my lord. But the thing, the proceedings adopted by the learned trial court is something else that the procedure more than that.
Yes, Mr. Mukherjee.
But, since both of them had argued on merits also, may I come back on Monday?
Monday will be
then Tuesday.
Day.
Yes, Tuesday. Tuesday.
Saturday, yes.
Saturdays then. Saturdays.
Saturday, Mr. Mukherjee.
Saturday,
Why not? Mr. Rai and Mr. Chaudhary will be there.
I'm
but
coming.
Don't appear online.
No, I'll be physically here.
Yes, Mr. Chaudhary will be there.
Since Mr. Chakraborty is also there, kindly apart from
ask him to come on
Saturday, kindly makes it to Tuesday.
Since February, whether I'm
yes, he's suffering an interim order.
I'm suffering the order of injunction for no fault of mine. It is a fault of the court or by the court, I do not know.
So Mr. Rai has not sufficiently has make aspersion against the judge, but I will rather try to demonstrate before your lordship there are the procedural irregularities even in lodging of caveat since they are on merits. But today also I shall make my submission first with regard to reply of their argument on the point of maintainability. Then only if your lordship is not with me, I shall argue on merits. There is nothing on. I have seen their argument so far as regards the maintainability is concerned. I shall first give your lordship the reply on maintainability. And if your lordship is not with me, I shall argue on merit also. Tuesday. Wednesday, kindly.
Friday.
Have it on Tuesday. Or we can have it on Monday also. What if
Yes,
it's monthly list? Let us have it on Monday.
In the monthly ballot, there is no problem. So,
but I don't have any problem on Monday.
No.
Yes.
এক্সটেনশন অফ এন্ট্রি করতে বলেছিল
আচ্ছা ইয়ে হবে না, এই যে আমরা সাফার করছি
66, my lord, I am for the petitioner. My lord, I have served on the advocate of the opposite party.
চিঠিটা দিন none appears এক জায়গায় দা এক জায়গায় considered. Yes, next.
Lordship, I am for the petitioner, your lordship. Tomorrow, the extension of interim order is going to.
The affidavit of service filed in court.
Lossy, I am
I am the plaintiff opposite party.
Lossy, I am appearing of
Updated, the only one from a fixed.
Lossy.
I don't have regular determination.
Yeah.
Limited. Limited.
Lossy was it was
I am suffering, my lord.
extended on to 12.
August, I will extend at the time when he mentions again, you argue.
Instead of August, September.
No, my lord. August, I am suffering with the lanet code.
We same have it. Petitioner or party? Next.
69, Lord, I am for the petitioner. Lord.
69, my lord, I am for WBSCTCL.
Lord, I am for the petitioner. Lord.
And one is for extension.
Extension of interim.
Can 1 of 2026 has been filed for extension of interim order. Full stop. You are appearing for the. Next. Can one is disposed of.
The line for the interim order till 31st of July.
You are appearing for the. Having heard the parties. Yes,
yes, I understand it.
Petitioner shall serve a notice on the opposite party. Next.
I'm appearing for the petitioner. My interim order is expiring tomorrow.
Only petitioner at end of August.
Claim for execution of the interim order dated 12th of May 2026. Did not appear, my lord. My lord had on the last occasion, my lord had directly I have served, but the affidavit of service is not with me, my lord. My lord, I
submitted by the learned advocate for the petitioner that next.
I'm for the petitioner, my lord.
I'm waiting for the petitioner with my learned junior, my lord. The interim order expires tomorrow. So I'm praying, I'm having an ankle fracture also. A slight bit of longish time may be granted, my lord. I cannot go personally to do the hearing before September.
This is
It's
a
my
nice execution
personal
case.
problem.
I am extending it till the end of August. You argue it.
My lord, September would be the best part because I cannot go before 6 weeks, my lord. That's the problem.
After 1 month, let us see what happens.
Okay.
Can 1 is for extension, can 4 is for
Can 4, my lord, can 4.
For extension, my lord, can 4.
Application for extension of interim order. Full stop. Having heard the learned advocates appearing for the respective parties, the interim order granted earlier is extended till the end of August 2026. আচ্ছা ওখানে উপরে লিখে দিন যে Mr. Basu, learned advocate, submits that he is unable to attend court due to since he has suffered a fracture in his ankle.
Yes, madam.
Paragraph. Having heard advocates appearing for the respective parties and having considered the material on record, the interim order granted earlier stands extended till the end of August 2026 or until further orders, whichever is earlier. List this matter before the regular bench according to his lordship's convenience.
I don't think my learned friend on the other side would have any problem, my lord.
Suppose that
it's a personal problem. I'm grateful, madam. Grateful.
Lordship, I'm appealing for the opposite party number 1, 17 and 18, Lordship.
I'm appearing.
Kindly extend it up to the
virtual. Yes.
I'm for the petitioner. Lordship, I have already served copy upon the revisional application upon the opposite party and affidavit of service already on
the
record.
second time is extension is application is going on. Limited period of time is to be given, otherwise
having heard the learned advocates appearing for the respective party and having considered the
Seventy-six lordship. I beg to appear on behalf of this.
Can for extension, can 1?
Can 1 is for extension.
My lord,
Extending it for a limited period before the regular
my
bench
lord,
get it heard.
in this matter, the respondent number 1 and 8 has already been died.
Oh.
Expired.
Then
1, Ruby Dotto. 1 and 8.
Party number 1 and
Sir, death certificate
Oh, নামটা
the learned advocate appearing
But I'm appearing on behalf of the petitioner, ma'am. But I have served notice after mentioned.
Learned advocate appearing for the petitioners. Next.
78, my lord, I appear for the petitioner. The
For the
interim order
opposite party.
expires tomorrow, my lord.
But the interim order
May be extended and
may be extended, but your lordship, the interim order in this matter was passed on 24th of November 2025. It was modified on February 23, 2026. Yes, but modified interim order may be extended.
The point was made. Heard learned advocate, having heard the learned advocate appearing for the respective parties and having considered the material on record. The interim order passed on February 23, 2026 shall stand extended till the end of August 2026 or until further orders, whichever is earlier. List this matter before the regular bench according to his lordship's convenience.
deeply obliged, my lord.
Lord 69, my lord, I'm for the petitioner, my lord. It's interim order expiring tomorrow, my lord.
Same order, having heard the learned advocate appearing for the respective parties, extended till the end of August. End of August.
Very good. Deeply obliged.
Next.
Interim order is the end of July, my lord. Evidence service.
Affidavit of service filed in court today is taken on record. None appears for the opposite party. I cannot extend more because this is not regular bench. It won't be.
Yes, your lordship.
Yes.
My lord directed me to serve a notice again. Right, sir. Last of it.
Affidavit of service filed in court today is taken on record. None appears. You are appearing.
Madam, I'm for the petition. Madam, interim order expires tomorrow. That is end of July 31st of July. Madam, I have served upon all the opposite parties. Madam, opposite party number 1 and 2, madam, there is no update in the server. And so far as 3, envelope returned with the endorsement, postal endorsement, addressee absent.
Affidavit of service filed in court today is taken on Yes.
Extension of the interim of my lord's 23rd June order. This extension cannot be granted at all. Even the initial order of young stay that has been passed against a dead person. I pointed out before your lordship on 23rd of June 2026 that the one of the plaintiff have died.
And I don't think, did I pass any interim order on 23rd?
No. Prior to that, the coordinate bench has passed an order, with ignoring, since I was not on caveat, that one of the party to the revisional application died. And after your lordship's order dated 26 June, they have applied before the trial.
Let it appear before the regular bench on 1st of this August. Till tomorrow, you have an interim order?
Yes.
1st of August, it will appear. 1st August till list din.
Well, only let me make my submission. He has made the submission. Let me make my submission. Now, my lord,
I don't have regular determination. I will not
but
be able
then you also kindly extend the interim order.
interim order against dead person.
Dead person now.
This was not the
No,
submission.
against the dead person now.
Mr. Dotto.
Let me make my submission.
Very well.
On the Tapos Bose was the plaintiff, number one. Now, transposition application was made for bringing you as a defendant. Now, my lord, the transposition application was rejected, but we are under the impression that that application was allowed. However, Tapos Bose was made as a defendant. Now, my lord, he died 19 March 2026. You will also directed me to add them legal years of Tapos Bose.
Then there was a clarification given by this court on
Yes, on 23rd June.
Yes, rejected. Now we filed an application for expunging him
before the trial court.
Before the trial court. That expunging application is pending before the trial court. Now,
oppose that before the trial court.
Whatever you oppose, let it be adjudicated before the trial court. Now,
when is the next date before the trial court? What will happen if this interim order is not extended? Which heaven will fall? What will happen?
The suit will be proceeded.
How? If the suit has the date on 31st or 1st of August, only then it will proceed. If the suit has a date of 15th of September, will it proceed?
8th of August.
So therefore, before 8th August, you have the option to go before the regular bench, sir. That is what I was saying.
Only I am paying my lord.
Yes.
7
because
days.
in the wake of this submission that some parties are dead, I do not know what is the situation there before the learned trial court. I don't have the regular determination. In the
that's why, that's why you lost
it.
fix this matter first or 2nd August before the.
Yes, that is what I am doing.
But till whatever.
Nothing is going to happen, Mr. I will record the submission that this the date before the learned trial court is on 8th. Therefore, parties will move before the regular bench before 8th. In any case, it will be listed.
আপনি কি শনিবার আসবেন? শনিবার রাখছি।
শনিবার আমি আসবো।
সোমবার করে দিন।
Monday.
সেটাই বলছি আজ।
The interim order is going to expire tomorrow.
This is that matter still continuing. Having heard the learned I'll extend it till August. Having heard the learned advocates appearing for the respective parties, the interim order granted earlier and extended till the end of August 2026 or until
Extension of interim order, it's expiring tomorrow, my lord.
And for the opposite party, my lord.
same order.
Here is the notice.
Same order. It's appearing.
Well, still very well.
Yes.
Lordship, in 88, may I be permitted to appear virtually?
Yes, why not?
Lordship,
I can't pay for extension. Service IP. Kindly make it not. My lord,
Lordship, I have not been served with a revision application, and even today the matter is appearing without any notice being served upon me. It is the list that I have seen and I'm appearing.
I'm making it not today. Can you come tomorrow then?
Yes, Your Lordship.
Not today.
Grateful.
89 minutes.
89 I am for Kolkata.
The interim order is still tomorrow.
Having heard Dupokhoke. বাকি আছে দিদি অ্যাপ্লিকেশন উপরে করবে তো ধরা হচ্ছে না
My lords, I'm for the petitioner, my lords. This is a matter regarding a domestic electric connection applied by us.
We are waiting for the opposite, I mean, to respond.
Opposite parties were there in the first half, but now I cannot see them, my lords.
Not today.
Lords, it has been numerous occasions. It has been adjourned. I understand, my lords, because of this.
Chalo. If both sides are there, I'll take it. Call for it.
I'm for the petitioner, Your Lordship. Kindly pass over the matter. My senior is another.
Not today. Sir, 27. That side to nahi. Uni thake ki korben?
Sir, possible.
Good.
Lord, I appear for the petitioner. 32.
I am appearing on behalf
On
of
the last day, Lord, there was an order to add the corporation as a party. There was a 412 notice. Lord, I have challenged that notice and the proceedings before the coordinate bench, Lord, of the Code number 3, my lord, I've challenged. It's pending. It will come up tomorrow. My lord, will it be my lord's pleasure? My lord, what I would indicate. If the KMC has been served, the KMC should be here. For KMC is here. My lord, I believe they are also not ready with the matter. It's short notice.
Yes.
This very short notice they have given, they've been put, my lord. The difficulty is, my lord, if it would be my lord's pleasure, but kindly don't take me amiss. My lord, it can be taken by a single court. I can also inform that court. But it's a consequential relief that it's happening. My lord, it's 412 is there, my lords of the view. Because there is a 412 order, my lord, the electricity connection cannot be given. That is, to my deepest of my understanding, my lord, and with utmost humility, my lord, it should be taken up by a single.
I'll release it then in that case.
My lord, I would not utter that. But it would be my lord's. And one more thing, I would be praying, my lord, for a my lord, interim order. But that might be what I was saying.
I can't have both. Either I release or I retain. Can't be both. I'll release it with liberty to you to mention it before the appropriate member. Then it has to be assigned.
Yes, so it needs to be assigned then.
Yeah, I cannot assign.
Listen, because in view of the matter,
I can do this, that I can adjourn it, get that adjudicated, and you come here. That can be done.
Well, difficulty that can also be done. I was primarily I would be praying that. But what I was saying, the corporation is here. Because I am suffering. There is an order in which I was not served. Well, I know notices were served. But today,
that is not before me. So
that's all right. Corporation is a media party only with the intent of what is the present scenario. The corporation can say what's the present scenario. The building is a 100-year-old building. I have it's not at all dilapidated or it's not condemned.
Already.
There's no electricity, basic necessity.
Yes, I am releasing it so that it can be heard. cross over their
It's
residential.
a co-sharer property. One pole is to be installed.
Pole has been installed, my land to be taken up on the bank of the pond. That particular 10 feet land is co-sharing property.
Will go overhead the land.
Yes, my lord. Out of 58 feet, only 10 feet is this.
And what is the problem that they are having?
Well, they are not allowing us to install pole. Our contractor will not had been to the premises and returned back due to their vehement objection. That's the difficulties. Because we have no objection, we are ready.
Taking it at 233. Till 230, it was appellate side.
No, that's it.
Very well. Affidavit of service filed in court today is taken on record. একটা কাজ করুন না দিদি, এটা কালকে টপে রেখে দিন। Keeping it tomorrow at the top. এই একটা নিউ মোশন টপে রেখে দিন।
অর্ডার হয়ে যাবে।
Please give that.
ওটা দিয়ে দিন আপনি।
Affidavit of service filed in court today is taken on record. It appears for the private respondents. WBSCDCL is represented through Mr. Kole. List this matter tomorrow. Full stop. If the respondents remain unrepresented, private respondents remain unrepresented, the matter may be dealt with in their absence.
Well, grateful to you.
My lord, item number 29, my lord, other side here.
No. Now original side will be happening.
Original side.
Item 29 was what matter?
My lord, directed to file report.
Take time.
They will not take time. We shall file exception. Only this order, my lord. Kindly fix a date.
This order I will pass on the next day.
Very
33 is the next matter, my lord, relating to new connection.
The other side.
My learned friend is here.
Private respondent must be there.
They have filed a report. They have served a copy of the report to us. As per the report, my lord, there are three persons for whom who are raising objection. For whom for that reason, my lord, new connection cannot be effective.
My lord, may I be permitted to file report?
Wait, then you have filed your affidavit of service.
Yes. My lord, these three parties are not. These three persons are not parties here. So, if your lordship allows me, I will make them the party.
Add them as party, serve them.
Yes.
Madam.
33.
33.
Report in the form of affidavit filed on behalf of the respondent number 2 is taken on record. Full stop. It is submitted It was not that you wanted publication to be done. You had already done the publication.
Yeah.
Malad, this is my application. What has happened, Malad? I filed a PLA application. Certain defects were found out by the department concerned. Thereafter, for removing the defect, I had to file a amendment application, a PPL amendment application, and when I went to file in the central filing department, it was found out that that the matter was placed before the appropriate bench, and Honorable Justice Kapoor please to dismiss this application. This is my restoration application. No.
This is an application for restoration.
May it please your lordship. I'll just indicate this was an application for grant of probate file. The lordship would recall when we filed the probate, there were certain legal developments. Your lordship, some properties were which outside jurisdiction. There was an order of the learned single judge. You have to file an application for citation. Then it carried to the appeal court. Appeal court said not required. So at that point of time, this application GA2 was made for issuance of citation, which is I believe not required now. My only humble request. All the consents are there, formalities are complete. If your lordship, there is a department to take it up tomorrow or day after, when the grant can be issued, or next week.
Very well, but this application you have to then withdraw.
Then I will say is withdrawn in view of.
Yes, of course, whatever. Judgment. Grateful. Not today. হ্যাঁ হ্যাঁ নট টুডে মানেই তো মানডে, কালকে থাকবে না। Not today. তাই লেখা আছে নাকি অর্ডার? দিন তো অর্ডার করে দিই একটা। দে লিখে দিচ্ছি, অর্ডার লিখে দিই। আইটেম নাম্বার 4 এ অর্ডার লিখি, তারপরে 5 এ, তারপরের দিন তাহলে ডিসমিস করতে সুবিধা হবে। Pays for the petitioner, let this matter go out of list. Ordered. Ordered.
Well, in application are 7.
7 this.
Issuance of citation method upon the sons and daughters of the deceased and the West Bengal administration, because it is 278 by the creditor as per section as per chapter 35 rule 8, there is a provision, then we need to cite it upon the Administrator General of West Bengal. That is my prayer sheet.
এটা দিন মাস্টার সামান্স।
Well, it is the original probate application.
abroad থাকে। লিখে নি। This is an app for grant of letters of administration. Full stop.
Grant of letters for administration.
I appear on behalf of the petitioner. It's a non-contentious probate application. The testator died in the year 2009. There's a registered will dated 6th May 2009, and the testator died on, my lord, 15th August 2009. My lord, leaving behind 3 legal heirs, the wife and the 2 sons. All the heirs have duly given their consent, my lord. The orders may be passed. Dada? Dada?
Only widow and 2 sons.
Yes, the widow and the 2 sons. The executrix is the widow, my lord.
Okay, we can. This is an application for grant of
Wait for
ডিভিশন বেঞ্চ আছে মনে তো হচ্ছে না কতক্ষণ চলবে আমি তো জানি না 4:30 4:20 যদি চলে Not today.
Lordship, I am led by Miss Shuchishmita. She is online.
Call করে যাক। Not today.
Lordship, I'm appearing. I'm being led by Mr. Shamritha Sen. I'm praying for not to be Lordship.
Lordship, I'm for the petitioner. This is the application for the grant of probate of the last registered will dated 18th February 2000.
Do it or you want time?
No, Lordship.
Today, next.
Let's item 20, I appear for the petitioner. my lord.
Yes.
20. I'm for the respondent number 2, my lord.
List. Item 20, my lords.
Half of the respondent number 2.
You're just appearing on behalf. You want to do it or you don't want to do it?
My lords, I want to do it, my lords.
Petitioner.
I beg to appear for the petitioner, my lords.
I have filed my opposition, Lordship.
My lords, I would clarify what is left out in this matter, my lords.
You're ready with the matter?
Yes, ma'am.
Very well. Then.
This is the same matter which I mentioned physically before your lordship from last 2 days, my lords.
Yes, what is the matter? Tell me.
Yes, my lords. My lords may have the last order which is dated 22/1/2026. My lords, the second page would just clarify what is left out in this matter, my lords, if I may read out.
Who is appearing for the respondent number 1?
Victor Moses was on record, my lords. Perhaps they are not appearing. We have sent them notice to appear before your lordship to cause appearance. They are avoiding with naturally, my lords, because they have to pay the interest at the moment, my lords. Anyways, my lords, the issue remains is the interest be heard by granting all parties to ventilate their grievance in the said application by giving them an opportunity to disclose their respective stand by way of an affidavit.
What are you reading, Mr. Ganguly? What are you reading and where are you
My
reading?
lords, the order passed by lordship, my lords, Justice Arindam Mukherjee, dated 22nd of January 2026.
Yes.
So the only issue remains is the award or amount of interest that has to be granted. For the period, the respondent number 1 has withheld the amount that was transferred by respondent number 2 Federal Bank from the deceased estate, my lords. By way of background, my lords, I may submit, my lords, 16/10/2025's order was the injunction order passed in favor of me, and thereby restraining the banks to transfer or transfer the funds that are lying in the deceased bank account to the nominee, who happens to be my uncle, respondent number 1, my lords. My lords, there was a specific direction with respect to respondent number 1 that he has to secure this amount, which has been already transferred, and they have done that job. And now the only point remains is the grant of interest. They have filed their affidavit, my lords, by now. We have filed our rejoinder. My lords, I leave it in your lordship's hand to grant an appropriate amount of interest and dispose of this application with a stringent time frame that they must pay it.
My lord, if I start his arguments.
Yes,
I filed my
he's arguing.
Very good.
He's arguing. Yes, what is there there to oppose for you, Mr. Dashgupta? How you are opposing this?
The issue is whether
You have paid the principal.
I have secured.
You have secured the principal. What's the interest?
Now, my lord, insofar as the entire amount is concerned, the money belonged to somebody else.
There is no reply on record, Mr. Ganguly.
My lords, our reply we have filed. My lords, the rejoinder is there. This is dated, filing date is 19th of February 2026.
19th February 2026 file.
Right, my lords.
No, it's not on record. Where did you file it?
My lords, with the department only, my lords. The advocate and record has filed it already.
Order দিয়ে দেবো? Order একটা দিয়ে দিই যে reply is not on record.
My lords,
It's
we
not.
have our copy. If your lordship wants to pay.
Your copy won't do. I should have a copy
Yeah,
before.
I understand. I understand what's fall from your lordship, my lords. But we have filed it, my lords.
I have a report.
Mr. Ganguly, learned advocate appearing for the petitioner, submits that he has already filed an affidavit in reply to the affidavits in opposition. Affidavits in reply to the affidavits in opposition filed on behalf of the respondents. Full stop. However, comma, কোনো affidavit নেই কোনো affidavit of reply নেই reply কিছু নেই. However, comma, no affidavit in reply is on record. Full stop. The department shall incorporate the affidavit in reply filed on behalf of the petitioner in the records. কবে রাখবো? সোমবার হয়ে যাবে তো? List this matter on Monday.
My lords, to be mentioned if possible, my lords.
It will be at the same place where the final disposal matter you mentioned.
Grateful, your lordship. Grateful. Monday, my lords. So grateful.
Next. Not today.
My lord, I
You're
appear
there.
for some of the respondents in this, my lord.
Petitioner has to be there.
My lord, the affidavit in opposition is to be filed, my lord.
Affidavit in opposition. None appears for the petitioner. Affidavit in opposition filed on behalf of.
My lord, this is a PLA matter, my lord. These are not respondents yet, my lord. They are some of the legal heirs.
Has been, it has not become contentious.
No, my lord.
Affidavit in opposition. Then what is this affidavit in opposition for? If it is not contentious, yes.
My lord, this has been, my lord, the issue that had happened, my lord, is that there was an application filed by the petitioners, who is one of the heirs, who is challenging the validity of the will now. My lord, the citations have not been issued. Nothing has happened in this. This application has, however, come into this, my lord, this matter, my lord. So none of the heirs have become respondents. Only the application is now pending.
I am appearing in support of this application. The executor is before your lordship. A affidavit have been exchanged, my lord. May I file this affidavit? This is an application taken out by the executor for injunction restraining all the legal heirs of the deceased testator for dealing with the property till disposal of this probate proceeding. May I tell you the facts in here? Not the testator, who is a Sikh, made his last will and testament on 21st of March 2020. Thereafter, the testator died in November 2020. Testator left his wife, 2 sons and 2 daughters. After the death, the executor named in the will, being the eldest son, filed this probate application before this honorable court, which is PLA number 8 of 2026.
My lord, at the outset, my lord, I'd like to apologize. I'd made one mistake in this. My lord, the application is by the executor. My lord, I had made that mistake.
In regard to the prima facie observation by the coordinate bench, my lord, বইটা আছে তো?
ওয়ানটা বার করো।
Yes, how would you cross the hurdle of section 269?
Well, may I place this judgment? Well, Lordship was also party to this recent decision held taken.
No. This was on an absolutely different thing. This judgment of the division bench which you are citing was an absolutely different aspect. 269(2), you have the.
Yes, ma'am, I have.
When will the district judge have power, or when will the High Court have power? It's not that the Succession Act itself doesn't apply to the grant of probate.
Parallelly, section 300 is also there.
Well, maybe there. Merely because you file an application, therefore there has to be an injunction on your application. How? This judgment is not going to topple this kind of a question. That is for a different. This discusses a different issue altogether, as to whether probate can be granted or not. To what extent injunction can be granted by a probate court was not the question which had fallen for consideration.
But since the 300 is there, 300 is having a concurrent like other district delegate to deal with the testamentary position matters, and that is
beyond. If it is concurrent, then by that logic, all the more section 269 will be a hurdle in your way. All the more be a hurdle.
That means may I come back?
Come back. I will also think over it.
Yes, madam. That is okay.
Affidavit in opposition. And affidavit in opposition and affidavit in reply. It is filed in court today at record. Full stop. Paragraph. As paid for.
Under item number 22, I beg to appear on behalf of the defendant, my lord. May I file my affidavit in opposition?
Not this week,
There is a prayer for not today.
Not this week, Lordship. Not this.
May I file my affidavit in opposition? It is the original is lying with us.
Affidavit in opposition to recording. Affidavit in opposition filed on behalf of the defendant is taken on record. Full stop. Learned advocate appearing for the plaintiff prays for an adjournment. Full stop. List this matter 1 week hence.
May we come back? Very good. 1 week hence. Grateful, my lord.
Yes.
My lord, will it be your lordship's pleasure to hear out item number 13? I'm sorry, the bench was not sitting then when I logged in. Some other matter was going on. I couldn't respond on time, my lord.
Did it not today?
Very well, then I shall come back. Otherwise, I was ready. I could do the matter. My junior was also waiting in court.
Item 1-3.
Yes, 13, your lordship. Item number 13. It's for grant of probate, your lordship.
Deal.
Sir.
My lord, may I present this, my lord? The application is for grant of probate, my lord, taken out by the sole executor, Chandrasekhar Nopani. The deceased testatrix, she left behind the last will and testament, which is a registered will, dated 5th of September 2017, which is Annexure A to the petition, and she passed away on 26th of November 2022. The death certificate is annexed as Annexure B to the petition. Then your lordship will find that 2 of the attesting witnesses named in the will, Bhagwati Prasad Sharma and one Shurojit Pine, they had given their affidavits. So affidavits of attesting witnesses are enclosed to the petition as Annexure D. The husband of the deceased testatrix, my lord, had predeceased her. His name is duly mentioned in the body of the will. The natural heirs who had survived the deceased testatrix are the two daughters, Vrinda Kanoria and Kusum Lata Kajaria. They have both given their affidavits of consent, which are affirmed duly on 22nd of September 2023.
Affidavit of consent গুলো একটু দিয়ে দিন।
Annexure E to the petition.
এখানেই আছে।
Yes, Your Lordship. Annexure E, affidavits of consent by both the daughters, affirmed on 22nd September 2023. Now, one of the properties was situated in Mumbai, and it was during the time when the Honorable Division Bench had not clarified the position. So at that juncture, we had given an undertaking that we shall carry out the necessary obligations under 283(3). And then, my lord, there was paper publication done pursuant to orders of this Honorable Court on 28th of January 2025 and 10th of March 2025. On both the dates, orders were passed. And in pro tanto satisfaction of that, paper publication was done in 2 newspapers. And so today, my lord, everything has been complied with. I'm only seeking prayer in terms of prayer, order in terms of prayer.
করে দিন। লিখে নিন। This is an application for grant of probate of the last will and testament dated
5th September 2017.
2017, left behind by the deceased testatrix. Full stop. Paragraph. The testatrix is survived by her husband had predeceased her.
Had predeceased. It is mentioned also in the body of the petition.
The husband of the testatrix had predeceased her. Full stop. The testatrix is survived by 2 legal heirs who have been described in paragraph 5 of the petition. Full stop. And the executor is outsider.
Sorry, Your Lordship.
Executor is an outsider.
Executor.
He's not the heir, not one of the heirs.
No.
Both the legal heirs have filed their affidavits of consent, thereby consenting to the grant. Full stop. Paragraph. The will has been proved in common form by the affidavits of the 2 attesting witnesses. Both have filed affidavits.
Yes, Your Lordship. Both have filed affidavits, Annexure D.
2 attesting witnesses. Full stop. Paragraph. Since the files have been placed before this court by the registrar insolvency, upon complete scrutiny, considering the view of the department, the application for grant of probate is allowed by granting order terms of prayer of the petition. Full stop. PLA 376 of 2023 stands disposed of.
Grateful to you.
The caveat certificate has also been issued upon issuance of citations.
Grateful.
Satisfied? ডিপার্টমেন্টকে ইনকর্পোরেট করতেই তো বলেছি, অসুবিধা তো কিছু নেই। কল করে দিন, আমি উঠে যাবো, কল করে উঠে যাবো, শুধু লিস্টেরটা কল করে দিন। হ্যাঁ, কল করে দিন, কিন্তু এমনি এমনি খালি খালি উঠে দিতে পারবো না। যদি কেউ থাকে ওয়েল অ্যান্ড গুড, না থাকলে কিছু করার নেই।
Lordship, I appear for the respondent.
The side is not there. Let us see, both sides are there, only then I will take. Otherwise, in this flux, necessarily it doesn't make sense. I have a duty to call, so I am calling.
Lordship. 37 and 38 also, my lord, I appear.
Yes, yes. If both sides are there, only then I will take up or pass orders. Call korun, call korun.
My lord, in item number 44, my lord, Mr. Shoikat Raichudhuri, the applicant had contacted me in the morning itself to check that he wasn't feeling well, and that is why.
Very well. I have not done anything. कोई तो नहीं, पहले उठे जाए यार, की करूं? Okay.
Really? 44 take now, not today.